executed? I didn't see it.
Yeah, I have it in my email. I believe.
you-
Let me take a look.
Can you print out a copy and have somebody run it down, please?
Yep, I sure will.
Thank you. All right. Brandon Luis Hernandez Valdez. 260-150-0090. Mr. Darren, your appearance.
Good morning, Your Honor. Nicholas Tarrant on behalf of Mr. Hernandez Valdez.
And so you were authorized into this plea. You're going to plead responsible to 1 to 5 over, and they are going to dismiss the failure to yield, correct?
That's correct, Your Honor.
And you're authorized to enter this plea, and you know there's a point to that, correct?
I am authorized and I'm aware of the points.
All right.
He is.
No, he's not here.
Oh, he's not?
Yeah.
David Marino?
Yeah,
Mr. Marino?
Mr. Marino, Hello, Joe.
When you had the card that they held the sheet, and every time Tom would come up, he'd open the card.
Just another day.
Yeah, I would label that tiresome. Yes, that was
Talking about me before I
painful.
got
And every time you played, no one stood. I just wanted to make that as a fact. No one stood.
No response, Your Honor. I'm going to sit here just a couple of minutes. These should be.
Yeah.
We can hold him in custody.
He came in.
All right. Okay. Well, 26 CR 651 was called David Marino. There is no answer according to the bailiff's call outside. David Marino, no answer to the name called here. Defendant has failed to appear. A warrant shall be issued for his arrest. What is his bond name? There. Some gross. I don't know gross people to fail to be here regularly. They do a good job.
I got you on time today.
That makes one.
Oh, she rose. But it's $12,000, so.
Where do those bond numbers come from? I mean, well,
The arraigned judge.
it's like not, it's like $4,875.23. Where's the rounding off of it all? All right, his bond is $12,000. And again, we'll make tentative findings that he has failed to appear. Thus, his bond is revoked. A warrant shall be issued for his arrest, and his bond is doubled to $24,000. That's not the name that's used on his wanted posters. His wanted posters don't have that name. The lawyers are at each other's throats already. Anyway, it's a double to $24,000. A warrant shall be issued for his arrest, and he will be placed. He must have a GPS device. He'll be placed in home confinement, and is allowed to leave in the most direct route possible to and from attorney, to and from food,
This is
to and from work, and to and from medical care. That's not David Marino either. Nice try, Tom. Jessica
Yes, sir.
Williams.
She's great.
We'll see if something happens that will make sense.
Sure.
Giles will put it back together again. Maybe. All right, Jessica Williams, come on up.
She's outside.
Okay. Look, he's going to leave. We'll never see Giles again. Watch. Watch. Yeah. We'll find him in Las Vegas somewhere.
I'm saying, he is.
Is Jessica here?
Yes, she's standing by her attorney.
Man,
I'd like to hide.
people could have stood behind him.
Yeah.
I've never seen him.
Yeah, Giles is good cover.
This size, only this size.
In a violent situation, stand behind Giles.
Yeah, right. I'm gonna be running.
With everybody hanging on.
That's right. First half of the
Seriously though, this is something that you got to take care of responsibly. You're charged in 26 CR 634 with burglary of a habitation, first degree felony. So it carries with it no less than 5, no more than 9 years confinement in prison or life imprisonment. And you are Jessica Nicole Williams. Yes, to God, so she can hear. All right. This was indicted in April. What are we doing today? This announcement.
Yeah. Speak to Mike about this. He's in trial. I just actually listened to him.
Well, I know, but he's been in trial for 3 months.
No, he not.
It was not here.
I might be seeking off with.
It's in the file.
I didn't see it.
Well, what is it?
Yeah. The offer is 7 years TDC, Judge.
Does she have a prior conviction?
Reading through the facts, I think it's very fact driven, Judge, but I'll check the files.
Oh, I see. Okay, it's burglary with intent to commit another felony, and let's see. Burglarize, and that's burglary has its own punishment situation. Just if you enter a home without somebody's permission and attempt and to commit theft or another kind of crime, but here it also alleges that the defendant committed or attempted to commit or committed the felony offense of aggravated assault with a deadly weapon. Used a deadly weapon, namely a pistol, by threatening the victim by pointing it to the victim's head and stating, "You are going to die today, bitch." Well, that's not the way to enter someone's home. And that's not the.
Should have used a little bit more tact with retrieving the stolen wallet that the alleged victim.
So during the mention of it, while the victim was still on the ground. There were 2 other people there. During the commission, the victim was on the ground. One of the 3 people who was, one of the 2 others with the defendant.
Yeah,
Exhibited a pistol and threatened the victim, and "You're going to die today." During the commission of the burglary while the victim was still on the ground, brief, shocked victim by applying pressure to her neck with one hand and slapping her on the face. Jessica, Bree, and Ebony, the three, searched several areas of the apartment for a stolen wallet but failed to locate it. Subjects were removed from the residence and the firearm was retrieved and secured. And all three were placed under arrest. Okay. So I wonder how the police found anything.
Well, the police actually found that wallet. The alleged victim stole the wallet from the time she was sleeping in the vehicle. That
Yeah,
also,
but you don't put a gun to somebody's head and threaten to kill them.
well, Your Honor,
I mean, that's kind of a problem. That's
I would say that
There's no way to converse
I agree, Your Honor.
with someone.
That victim doesn't have clean hands. She lied to the police and told them that she didn't have a wallet.
So you put a gun to somebody's head and threaten them. Well, that's what the essence of this charge is. Maybe they're going to charge something else, but right now you're charged with burglary of habitation. And just because they find the wallet somewhere else or it's found, it's burglary of habitation. I mean, you entered somebody's home without their permission and then put a gun to their head according to the probable cause affidavit. And that's pretty serious all the way around. I guess that's why the offer is not a probation offer. So put on trial. All right. Set it on the trial docket. That's what we're going to do. And don't have, ma'am, here's one of the conditions of your bond. You can't have any contact with the victim. Okay. No one on your behalf unless the court approves it. So don't, and that's what's happening all the time up here. These side things are getting made and it's against the rules, but I'll just warn you. Yeah, Tom.
Miss Murray, I was here.
Well,
He was in county court number 2.
why?
Miss Murray?
Why?
He was in county court number 2.
Why? He's supposed to be in here.
Well, he has some.
Oh, we had something over there.
Yeah, they tell him.
Does she need to get she needs to get a resend.
And they tell him to report there first and then come to the felony. They called me in there. I told them,
Oh, ma'am, no, I need you to sign it right here on that.
It's chaos today. It's chaos.
It's CDC, Judge.
Yeah.
Have you retained Mr. Burbank? Have you paid him? Need to give him that chain. Seal the deal. As it was. On Marino, what have we done? It's done. You're looking at a 3rd-degree felony up to 10 years in prison here. What are you charged with in misdemeanor court?
He was on probation whenever this offense was.
Oh, it's a probation or everything? What's he on probation for? You know?
That's correct. It is a gun charge.
Okay.
Trial not to do that.
All right. That's what we'll do.
We need some consideration in what you did prior.
I don't think.
Where you raised double the bond.
That's all. He's here. It's all that revoked.
Okay.
He's back in the way it was before those findings because he wasn't here. He's here. He's purged. He's purged his sin. He's good.
Excuse, Judge.
Yes. Get a resetting. Jasmine Daniels. Jasmine. Come on in. Who's your attorney?
Oh, Alex, yeah,
Where is he?
yeah, what's your number story?
Oh, well, he didn't tell us that. Okay, have a seat. We're about to go back into trial and y'all are going to have to wait until noon. Good luck. But we got a trial we got to finish. Kevin Jefferson, where are you? And Comerford is your attorney too?
Oh, yeah.
Okay, he's not here. We got to wait until he gets here, but we're going into trial in a little while. Y'all are going to have to wait. I'm moving forward.
He's here.
He's not in this room. That's what counts. I'm not going to him. Does Burger King come to your house? No. James Hoskinson.
More Judge.
Hey, Brian Lynn's case was reset on Taylor Jackson. Brian? Okay, this is-
Yes, let me.
Okay.
Mr. Hoskinson.
Hoskinson. There's a sentencing on one of Comerford's cases. Okay. You know what you're charged with? State jail file. What are we doing?
Judge, we're just asking one last announcement date. We've got the discovery, we reviewed it, we're just making sure we've got everything in order. Try to
3 weeks,
good. The next time that was sufficient.
It was 3 weeks.
Thank you, Judge.
Okay, get a reset. On Taylor Jackson, where are you, Taylor? Jackson?
Sorry.
On this one, I got a note here, but is the defendant supposed to be here?
No.
Good morning, Your Honor. Christine Beecher, here on behalf of the defendant, Daniel Allen Foster. Your Honor, I understand he's had numerous pretrials. I am newer to this case, so I would like an opportunity to confer with the prosecution a bit further in regards to a few issues with currently the CPL holder. So if we could just adjourn maybe out to September. Mr. Foster also works seasonally doing landscape, just to give him an opportunity to get as much work in as
Miss Adams, could I get a notice of hearing from Mr. Foster for September 16 at 8:30 in the morning? He's here in person, so I'll give him a notice. He won't have to do it. September 16 at 8:30 in the morning. Mr. Foster, just have a seat right behind you.
Thank you, Your Honor.
And we will get your copy of a notice of hearing, all right? And I think that's all you have with me this morning?
No, I also have Mr. Rudy Perez.
Oh, he's here. Do you need to talk to him?
No, we're set to proceed.
All right, Mr. Perez, why don't you come on up? This is file number 2025-22457FC. The matter of the people of the state of Michigan versus Rudy Mario Perez. I have Christine Beecher appearing on behalf of Mr. Perez. And I have Dave McCready, yes, appearing on behalf of the people. This is the date time set for pretrial. I do show that I have a letter from Darren Coe stating that Mr. Perez has been compliant with his GPS tether. He remains at home except to make approved doctor or attorney appointments. So he's in compliance there. So Ms. Beecher, how would you like to proceed?
Good morning, Your Honor. Christine Beecher on behalf of the defendant, Rudy Mario Perez. Your Honor, we would like to set this matter for a jury trial.
Okay. How long do you think it would be?
I would say a couple days.
Including deliberations? 3 days, 4 days?
3 days.
3 days? Would you agree with that?
On the outside.
I'm sorry, Mr. McCready.
I would agree with that, yes.
All right, so Ms. Adams, I'm looking for a jury trial date starting on a Tuesday. And obviously, I think we're into October now and he's not in custody, so.
All right, I'm looking.
Or November.
Well, Judge, actually, our first available would be Tuesday, December 1st.
How about the 7th?
Monday? Is that what you're asking?
Oh, I'm on the wrong year. How about December 8th?
That is available also.
December 8th?
Thank you.
And I will set a final pretrial for November 18. And I will require that jury, and I'm writing all this down in a scheduling order, jury instructions and voir dire questions will be due by November 13. And the motion deadlines will be November 18 of 26. Ms. Adams, if I give you this, could you make a copy for Ms. Beecher and her client? And Mr. Perez, you want to have a seat on the back bench? We'll get you a copy of the scheduling order. Ms. Beecher, do you want one? Just put in your mailbox.
Yes, it's on my mailbox. Thank you, Your Honor.
All right. Anything else this morning, Ms.
No,
Beecher?
thank you. Have a good day.
All right, advance continued. Thank you. All right, Mr. Murphy, you're back. Tyler Daniels. Let me bring him back from Zoom. All right, so this is in the matter of file number 26-22552FH, 26-22553FH, in the matter of the people of the state of Michigan versus Tyler Gregory Daniels. Mr. Murphy, have you had ample opportunity to speak with your client?
Yes, Your Honor. Now, in regards to the felony charges, the offer, from my understanding, was for Mr. Daniels to plead in file 2622552, the possession of cocaine less than 25 grams and the retail fraud third, so that would be counts 1 and 2 in that file. There'll be a dismissal of any habitual offender status. I don't know if he had any on there or not. No further agreement about sentencing or anything else on that agreement. Dismissal of the other file, the 5-3 file. Now, in regards to the contempt of courts, I mean, Mr. Daniels wants to accept that offer. In regards to the contempt of courts, I think Your Honor had I thought you completed arraigned him on today, or if you need to complete that either way. We're going to ask to set those for pretrial for the sentencing date. I know that he was incarcerated in Lenawee County Jail for July 10th and moving forward, just trying to figure out what he actually was placing, because July 10th was the hearing date, the violation probation hearing date. But I believe that he was in for, sooner than that. I just got to get confirmation of that. So again, if you could just put that for the date of sentencing, I would ask the court to consider allowing him, because he's serving a sentence in district court, but that's only a 45-day. I think that his sentence will be up before his sentencing date comes up for this. I would ask the court to consider keeping his PR bond on the underlying cases and allowing a PR bond on the contempt. Because again, I think that he was in jail while he missed those dates. I don't think he was trying to avoid testing. But again, going back, he wants to plead guilty to possession of cocaine on 25 grams and retail fraud Thursday.
Okay, and
if that's still the offer from the people, if I got that correct.
Mr. Steen.
Can I have a moment? I know there's a written plea agreement, but it's from March, so I'm not sure if that's still the agreement.
Okay, I'm going to rate him on his contempt of courts.
Thanks.
So I'm not sure if I did or not in the interim. So,
and
Mr.
judges,
Daniels,
as far as the contempt, I do have down that he missed 7-3, 7-10, 7-13. I did verify this morning he was incarcerated on 7-10. So the only missed drug screen would be on July the 3rd.
And if I could speak, Your Honor, please. I called Darren after I missed that drug screen, and I know he said that he would give me a warning for that one, because I just started working. I got a job and everything, and I was keeping real busy, and I was just trying to keep everything going on with courts and stuff organized, and it was just kind of a mess around that time.
All right, but we still have
That's July 3rd, I think he's talking
the
about.
discharge paperwork from Bear River is directed, right?
Yeah,
So, Mr. Daniel, stop talking for a minute, please. So the violation of probation and motion affidavit, or I'm sorry, bond conditions, the motion affidavit and or order to show cause, Mr. Coe said, obviously you were incarcerated for a few of those. I don't care that you started a new job. If you're supposed to test, you're supposed to test. So the violation is that you failed to provide treatment completion, discharge paperwork from Bear River as directed. And now that you failed the drug screen only on July 3rd of 26, the others, he did verify you were in custody. So a contempt of court for violation of bond conditions can carry a maximum penalty of up to 93 days in jail. And that's on both of these files. Do you understand that?
yes, Your Honor.
And Mr. Murphy, how do you wish the court to enter a plea of not guilty on this contempt of court?
Yes, Your Honor.
Okay. And what's he in jail on?
He was on jail on a sentence for violation of probation down in district court. I'm not sure what if it was retail fraud or what he was on probation for down there.
So what was the violation down there?
I don't know. I didn't handle it.
So, Mr. Daniels, what did they violate you for?
They violated me for not appearing to my probation officer, and I was locked up them times that they told me that I wasn't I didn't go in to see my PO because I was locked up.
Okay, thank you. All right, so what I'll do is I'll enter a plea of not guilty on the motion affidavit or the bench warrant, or I'm sorry, for the violation of bond conditions. And I am, let me see. All right, so honor not guilty on the contempt of courts. And Mr. Sneed, have you had enough time to verify the plea?
I did. The offer is to have the defendant plead as charged to the counts in file ending 5-2 FH, and all counts in file ending 5-3 FH would be dismissed.
Okay. So.
Yeah, that's what I said, a long-winded way of saying it.
Yeah, he just had to verify it. So do you wish to plead your client today?
If he still wants to, my understanding was Mr. Daniels wanted to accept that offer. Do you still want to take that plea, Mr. Daniels, or do you want to?
Yeah, I do. Yes.
All right, so, Mr. Daniels, you want to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so Mr. Daniels, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead guilty on file number 2026-22552FH to count 1, controlled possession, controlled substance possession of fentanyl, less than 25 grams, which carries a maximum penalty of up to 4 years in prison and or a $25,000 fine, as well as count 2, retail fraud 3rd degree, and that carries a maximum penalty of up to 93 days in jail and or a $500 fine, or 3 times the value or difference in property stolen, obtained, or attempted, whichever is greater. So is it your intention to plead guilty to those 2 counts?
Yes, Your Honor.
All right. Are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, I am, Your Honor.
Ms. Adams, I think Mr. Perez is still waiting on his scheduling order.
Yes, I'm headed in right.
Okay, thank you. Now, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Murphy?
That's correct, Your Honor.
And Mr. Daniels, is that correct as far as you're aware?
Yes, Your Honor.
All right. If a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Daniels?
Yes, Your Honor.
You understand that any appeal from your conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right. Do you understand that?
Yes, Your Honor.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, sir?
No, Your Honor.
All right, how do you wish to plead to the charge that on or about November 26th of 2025 in Madison Township in the county of Lenawee, that you did commit the offense listed in count 1, controlled substance, possession of fentanyl less than 25 grams, guilty or not guilty?
Guilty.
And how do you wish to plead to count 2 on November 26th of 2025 in Madison Township in the county of Lenawee, that you did commit the offense of retail fraud 3rd degree?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Murphy?
No, Your Honor.
Mr. Daniels, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty?
Yes.
All right, so Mr. Daniels, on November 26th of 2025, you're in Madison Township in the county of Lenawee. You're at
Yeah.
Coles, right? Coles?
Yeah, Coles, yep.
Okay, would you agree Coles is located in Madison Township in the county of Lenawee?
Yes, Your Honor.
Were you inside the store?
Yes.
And it was open to the public, right?
Yes, Your Honor.
And then you tried to steal something, is that correct?
Yes, Your Honor.
What did you try to take?
I think it was a pair of shoes.
Okay, would you agree the value is less than $200?
Yes, far.
And
Yeah.
you had no lawful right to take that property, correct?
No, I did not.
And your intent was to deprive the corporation of Coles of the value of that property.
Yes, Your Honor.
Okay, and then did you also have fentanyl on you at that time?
Yes, Your Honor.
Okay, where was it?
In my pocket.
In your pocket, and you knew it was there, right?
Yes, I did.
And you knew it was fentanyl,
Yes, I did.
and you had no legal right to possess it, is that correct?
Yes, Your Honor.
Mr. Sneed, are you satisfied?
I am, thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, Your Honor, thank you.
Mr. Murphy?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Are you available September 11, Mr. Murphy?
Sorry, I have to check when, Lincoln's.
First weekend. Yeah, first.
Yes, Your Honor, yes, I am.
All right, so I'm going to set this for sentencing on September 11 at 8:15 in the morning. He has a PR bond on this file, Mr. Sneed. And do you have any position on whether he gets, he remains on a PR or?
I defer to the court's discretion.
All right, so I don't think he has a bond on anything in front of me, so I'll leave it that way. Yes?
Judge, it looks like bond was denied back in April, and he was taken into custody.
And just since April.
Mr. Daniels, when, no, he wasn't, not from April until now.
I went to rehab.
Yeah, he was in rehab. He got arrested in April, went to Bear River. So I guess maybe his bond.
Oh, yeah, so if you went to Bear River.
Yes.
I don't know, Miss Adams. Did we release him on a PR to go to Bear River?
I'm checking.
Or is it bond that he just got to go to Bear River and was supposed to return? Yeah.
Did he go to Bear River in district court?
When he went to Bear River, that was one of the things he has, there's documents.
No, was it ordered through district court or my court?
I actually don't recall. I don't remember.
Judge, I believe it was ordered on your court. I have notes back April 27th. He was on a wait list to go to Bear River, and then he was there at the beginning of May.
All right, so I will give him a PR bond on all these files. So that means, Mr. Daniels, you're not getting any credit on my files. But okay. Mr. Daniels, you need to understand, I don't care if your girlfriend's having a baby, you got a new job. If you're required to test, the alternative is you go to jail, right? Yes, so you don't get to have fentanyl charges and retail fraud and everything else and make excuses. So you will test with Mr. Coast. When you get released from the jail, you will report to Mr. Coast immediately, Monday through Friday, 8 to 4, and that you will test, no excuses. Do you understand?
I understand, Your Honor.
So I have no qualms about locking you up. And if you are dropping dirty and missing tests, well, your guidelines on that fentanyl means I could send you to prison. Do you understand that?
I completely understand that, Your Honor.
Okay.
Mr. Daniels, do you have an out date given to you for that sentence downstairs?
The 16th of August.
Okay, so I'm going to set this for sentencing on September 11 at 8:15 in the morning. And Mr. Daniels, if you are not in custody, you need to be here in person, okay?
Okay, Your Honor.
All right. The probation department is going to reach out to you. They're going to set up a time to interview you. It'll probably be before you get out of jail. But if you get out of jail and you haven't met with the probation department, you also need to report to the 3rd floor of the courthouse and check in with the probation department because they're going to need to do a pre-sentence interview. You'll have to appear for that. When you meet with them, be truthful about your background, the events that occurred. They'll prepare a pre-sentence report, and then we will see you back here on September 11 at 8:15 in the morning. You're not a veteran, are you?
No, I am not.
Okay. All right. So,
thank you, Your Honor.
Thank you. And Mr. Murphy, could you perhaps email any contact information you have for him to the probation department?
Yes, Your Honor.
Okay.
Mr. Daniel, we'll come talk to you again soon, okay?
All right. Thank you. Am I all set?
You're all set.
Thank you, Your Honor.
You're welcome. All right, I have Michael Dagger Margosian. I have Douglas Hartung.
Your Honor,
Hold on, let me call the case first. Let me call the case first. The state doesn't like when I talk about a case before I call it. All right, we have two files, 2026-22534 FC, 2026-22627 FH. This is in the matter of the people of the state of Michigan versus Andrew Coleman Lambert Jr. I have Douglas Hartung appearing on behalf of the people. I have Michael Dagger Margosian appearing on behalf of Mr. Lambert. I have an ex parte order rescinding access to tablet that was signed by Judge Olsaver in my absence, and Judge Olsaver must have set this for today, and we are here today. Now, Mr. Dagger Margosian, what would you like to say?
all I want to say is I just need to speak with Mr. Lambert in a break room.
So I am going to open up a breakout room. And Mr. Lambert, raise your hand so I know which one of you are. Okay, I'm going to put you and Mr. Dagger Margosian into that breakout room. Go ahead and join the breakout room. All right, sorry, Mr. Curtin.
This is actually pre-trial. This is a previous scheduled pre-trial.
Oh, okay. All right, I have another gentleman in jail room 5. What's your name, please?
Mr. Goodell, Theodore Goodell.
Oh. Okay, thank you. Let me get your file. Mr. Hackett. This is Mr. Hackett, if you're ready. Malika? Yeah. All right, I'm gonna skip up to you. All right, come on up to the podium. Miss Adams, could I get Malika Rembert's file back, please? Is that Miss Adams? I thought she took this file. Here she is. Oh, sir.
On this Walsh said it's okay to adjourn. And then also Mr. Hicks. But
I got good out, but I got to put in the record. Okay. Okay. So, Mr. Goodell, your attorney is in back and they're doing a stipulation to adjourn your file, Mr. Goodell. And I don't have the information on when it's being adjourned to, but Mr. Hackett will get in touch with you, okay?
I don't understand what.
Me neither. But they're adjourning it and Mr. Hackett will reach out to you, okay?
Okay.
All right, thank you.
Thank you.
You're all set. All right, so Ms. Rembert, this is file number 2024-21966FH in the matter of the people of the state of Michigan versus Malika Rembert. Your probation officer has asked that this be adjourned. So Ms. Adams, did you say how far out?
she did not. She just emailed that it's okay to adjourn.
All right, I'm going to set it out to September 23rd at 8:30 in the morning. I am going to quash the bench warrant. So September 23rd at 8:15 in the morning. And Miss Adams, could I get a notice of hearing from Miss Rembert? You have a seat. We'll get you that. Yep, just have a seat right behind you. And we will get you that notice of hearing. Jill, let's see what else I need. So this is Judge Anselm again. So I am ready for Harley Olmsted.
Okay,
Chelsea Miller.
okay.
And then whenever after that you want to get me John Jakeway, I can do the extradition too.
Do you guys do the Roberts too? I thought somebody called the Roberts.
Roberts, that was probably Judge Olsaver.
Oh, you already did, yeah.
We did it?
Oh, no.
No, that wasn't me.
So you get all favor these Roberts?
I am not Judge Olsaver.
Okay, sorry. Yeah, you go. Okay.
I'm ready for Olmsted, Miller, and Jakeway. And I'm Judge Anselm.
Okay, they have it here for all favor, I don't know why. Okay.
Okay, thank you. Bye. So, Miss Underwood, I also have someone here on a show cause while I'm waiting. So, are you on Harrison, Miss Underwood?
No.
Okay. So, Mr. Harrison, come up to the podium, okay? So this is file number 2024-51855DM in the matter of, Stephanie Michael Harrison versus John Barthel Harrison Jr. This is a date and time set. There was a motion affidavit and bench warrant filed because Mr. Harrison failed to appear for a show cause hearing on June 26th of 2026. So Mr. Harrison, I'm going to go through a contempt of court for failure to appear can carry up to 90 days in jail. Do you understand that?
I do.
Okay. Now, there was a, let me get back here. You're released on bond by Judge Olsaver. Yeah, okay, thank you. Miss Underwood, you were appointed on this on July 24th in front of Judge Olsaver. But, okay, so we're going back. I gotta get back to the show cause. Hold on. All right, alternate service. All right, so there was a motion affidavit in order to show cause that was filed on May 1 of 2026 by Stephanie Harrison. She stated that she would like to show cause on why 316 West Michigan Avenue apartment or number 22 property has not been paid off yet. Per the divorce judgment, Mr. Harrison was supposed to have paid off in May of 2025. And attached was a letter from 21st Mortgage showing serious delinquency. And then she attached a letter dated money code looks like April 28th of 2026 from a portfolio manager stating that this file has been referred for legal action to recover possession of property due to delinquency and payments. And then if we go back to the consent judgment of divorce, there was a requirement in that judgment of divorce that you were to be awarded the home. Let's see, defendant awarded the home at 312 Killbuck. Plaintiff is awarded the trailer located at 316 West Michigan Avenue, and defendant will pay off the remaining balance on the trailer within 90 days of the entry of judgment. So that is long past. Do you understand that?
I do.
All right. Are you able to pay that off?
I am not.
Okay. So, okay, and as I said, contempt of court carries a maximum penalty of up to actually 93 days in jail. And Ms. Underwood was appointed to represent you previously by, I don't know, we have the public defender paperwork done. So I'm going to take care of some other criminal matters and then we'll go back to you, okay?
Okay.
So go have a seat. All right, I have closing the jail room, Mr. Dagger Margosian. Who do I have in jail Zoom 5, please?
Harley Olmsted.
Do you need a breakout room, Miss Underwood?
I believe Mr. Dagger Margosian is handling that, Your Honor.
Oh, never mind. Never mind. Okay. All right, Mr. Olmsted, it'll be a minute. So, Mr. Hartung, we are back on the record with matter of the people of the state of Michigan versus Andrew Coleman Lambert Jr., file number 26-22534FC, 26-22627FH. So, Mr. Dagmar-Gozzian, have you spoke to your client?
Your Honor, I have spoken with Mr. Lambert. As this court is aware, this case has been going on for quite some time. There have been multiple pretrials. What I'm asking the court to do is to schedule this for a plea hearing. If we can schedule it for tomorrow or Friday, if the court has a 15-minute slot open. There's a couple things I want to speak with him in person, and I would feel more comfortable with taking the plea in person. So if the court has time tomorrow or Friday, I would ask for that.
Mr. Hartung? I don't even know if I'm available. Ms. Adams? Do you want to bring the book in, or do I have time Thursday or Friday morning?
You're not here Friday.
Oh, I'm not here Friday. Do I have time Thursday morning? I don't think so. I have recovery for it, but let's check.
Sorry to interrupt, Judge. Is this on Mr. Olmsted?
No.
Oh, this is Lambert. Sorry.
Sorry to interrupt.
No, it's okay. I'm all over.
Judge, you have, looks like maybe 7 sentencings and then a 9 o'clock, or no, a 10 o'clock. So,
No, can I see the book? So Miss Adams, but I have 11, right? I think I have 11.
That works for me, Judge.
That works. I have to appear by Zoom, but that works.
Is it all right if Mr. Hartung appears via Zoom?
That's fine. I will give Mr. Hartung a call today just to confirm everything.
Okay, and do we want to address for the review of the ex parte order?
My suggestion would be short term, we just keep that in place and continue it, and also add to it telephone.
So, Mr. Dagmar-Gozzian, Mr. Hartung is asking that I add no use of telephone as well.
My concern, Judge, is that, if he needs to get a hold of me, he just won't have that ability. I know that we already sort of addressed this issue when we dealt with the
I'm taking a plea. What is the? I'm sorry, I don't mean to speak on it.
Lambert, you need to stop talking, because we were here before on this, and I was very clear with you about my parameters, which allegedly you have violated. So, Mr. Dagmar-Gozzian, we're going to be back tomorrow where you can talk with him, and you are, able, of course, at any time to go to the jail and meet with them. But I am going to add telephone to that order, and Ms. Adams, can we add that as a bond condition? Or do you guys need to update the order? Or
however you'd like to proceed.
Why don't you just do an order revoking his access to tablet and telephone?
Sounds good.
Okay. All right. And then we will see you back tomorrow at 11.
Thank you.
Thank you.
And that will be in person. Thank you.
Can I speak to Mr. Dagger one more time?
Mr. Dagmar-Gozzian, do you have time?
That's fine, Judge. Thank you.
Okay. I'm going to reopen that breakout room.
Your Honor, do we have Mr. Newsome?
I do. He's right here. Adams, you need the book back. Mr. Newsome, come up to the podium, please. All right, this is file number 2024-1 22-22068FH in the matter of the people of the state of Michigan versus Michael Robert Newsome. I have Rhonda Underwood appearing on behalf of Mr. Newsome and Ashley Messer. What's your key number, Miss Messer?
It is 76062, Your Honor.
Thank you. Appearing on behalf of the Attorney General. This is the date and time set for a pretrial conference. Miss Underwood?
Yes, Your Honor. I would need to speak to Mr. Newsome for a second, if I could.
Mr. Newsome, follow my deputy. Follow Mr. Lucy out there and he'll hook you up. There you go. All right. I think, Dylan, do you have a case?
Yes, here's.
Okay, I'm sorry. I must have missed you on my docket. What's the name of the case?
Carrie Swift.
Oh, is way. 10:30. Okay. All right, Mr. Daggermark goes in. Give me 1 second. Get my people ducks in a row. Boy. All right, so I'm going to open up a breakout room with Miss Underwood and the hallway. Go ahead and join that breakout room and leave that device turned on and just come back in the courtroom when you're done. All right, so Newsome and Mr. Jagger Margosian, you said you're doing, is it Gage?
Mr. Olmsted, Your Honor.
Olmsted, all right. Mr. Olmsted, raise your hand so I know which one you are. Thank you. This is file number 2025-22171FH, people of the state of Michigan versus Harley Wayne Olmsted. I have Michael Jagger Margosian appearing on behalf of Mr. Olmsted. This is a contempt of court hearing. And then, let's see. Court hearing for failure to appear at a probation violation hearing. And Mr. Jagger Margosian, you said you were taking over this file because you represented them in district court. So how would you like to proceed today?
All that is correct, Your Honor. Michael Jagger Margosian for Mr. Olmsted. If I may speak with him in a breakout room, please.
So, hold on 1 second. Just changing the screen name. So I'm going to open up a breakout room and get an invitation. Just go ahead and join it.
Judge, you got the, I think it's jail room 5 that I'm looking for.
Oh, sorry. Which one's Olmsted? Oh, I did the wrong one. Sorry. You're both wearing the same color and I usually don't see that color, so I got it. Who's in jail Zoom 3?
Hi, Jake Way.
Okay. All right, so I'm gonna close breakout rooms. Hold on. Okay, so I'm gonna do it again. Jail Zoom 5 and Michael Jagger Margosian. That's right, okay. All right, and do you want to come back up here, Mr. Newsom? All right, so we are back on the record in file number 24-22068FH. So, Ms. Underwood, have you had time to speak with Mr. Newsom?
Yes, Your Honor. Mr. Newsom continues to work at Buffalo Wild Wings, Your Honor. I understand $100-some is taken out of his check every 2 weeks. He also has another obligation that he is paying privately, I understand. But I would ask for an adjournment for the payments at this point.
Ms. Messer?
Your Honor, I have no objection to that request. Just looking at Mr. Newsom's payment history, this is an arrearage only case. And from what I can see, except for May, June, and July, in which there were no payments received, he has paid every single month previously since 2023. Has paid at least something. So I have no objection to the request for an adjournment. I'm not sure what happened to his income withholding order for the last 3 months, so he may want to look into that. If he's still employed at the same location, that order should be taking money out, as there is at least an order on arrears with this case of $40 per month. But it looks for the last 3 months, no money has been paid towards this case. But overall, Mr. Newsom is reducing his arrearage and has continued to do so for a few years.
What's the total arrearage amount?
As of today, Your Honor, the total arrears, excuse me, let me see, there we go. It is $10,066.59. And just over 8,000 of that is owed to the victim, Your Honor.
To the parent, mother?
Yes, sir. Yes, Your Honor.
Okay, so Mr. Newsom, good job. You're making payments, trying to bring it down. If you have an income tax return coming back, we usually try to get that. But
That's why I don't understand, because they're taking out my check every week, so I don't know how they say that I wasn't paying for like the last 3 months.
So it came out of your check for the last 3 months?
Yeah, they've been taking out $100 every 2 weeks I get paid. They take out $104 out my checks.
For the last 3 months?
Since I've been starting this job at Buffalo Wild Wings.
When did you start there?
I'm not sure. It's been there for about 3 months, like 2 months.
So you probably need to talk to somebody, get your pay stubs. Here's what I would like you to do. Can you print off your pay stubs?
Yes, I can.
Okay, I want you to take them to Miss Underwood.
Okay.
If they've been taking that money out, it may not have been sent in by them.
Because I reported that I was working at Buffalo Wild Wings the last time I came to court, so they should have been like.
No, did you look at your pay stub and it said it took it out?
I don't get a pay stub, I go direct deposit, so I just figured they took it out. I never.
Okay, so hold on. When you first start a job, it takes a little bit of time to set it up. So it sounds like you were thinking they were taking it out, but they weren't, okay? So make sure it's coming out, and because you have a child support order, you need to check your pay stubs, okay? If you go back and look at them and they took the money out, it just didn't get sent in, you need to talk to your payroll department, okay?
So I can do that today then?
Sure. But you're doing good. You're making your payments.
Okay.
So if you started the job and it took a while, yes, Ms. Messer?
Mr. Newsom does, maybe this might be helpful for him to know, he does have another support case that is actually currently charging through Lenawee County. So what he does need to know is if you're making a payment, that payment is going to be split between those two support cases, and the majority of which, depending on the formula result, may go to the case that has a charging order as opposed to our case, which is an arrearage only case. So he might want to look into that, and that might resolve some of those confusion.
Okay, so Mr. Newsom, you have another case with a minor still?
I got another case with Court Damas, but I pay her directly to her. I give her $120 every 2 weeks. Or no, $240 every 2 weeks. I give her $240 every 2 weeks. I give her.
Okay, so here's my problem. If we're collecting child support and you're paying her.
I don't pay to you guys to child support for the court. I go pay to her for the front of the court. But I do got a second child support. I pay her separate from during job.
So there's no child support withholding on that fund?
No, there's not. I just give her money direct. Every 2 weeks I give her $240 every time I get paid.
All right. So Ms. Messer, I don't know if you can see that in your system.
Your Honor, I don't see that any credits have been given by that custodial parent due to a direct payment. But my system isn't that up to date on that other case since I don't have an open file on that. But if Mr. Newsom is going that route, then he may want to discuss a direct credit so he gets credit for that, as he has an arrearage on that case as well.
So Mr. Newsom, I need you to go downstairs and ask to talk to your caseworker.
Okay.
If we have an order that we're supposed to collect child support on that file and you're paying her directly, you're still gathering an arrearage on our file if she's not giving you credit. Do you understand that?
Yeah.
I'm going to guess there's a file because she's probably getting health insurance in the state of Michigan.
She gets Medicaid.
Yeah, and that's not free. You still got to pay for it. So you need to go talk to your caseworker about both these files. Okay? And I don't know who your caseworker is at this point because we have a lot of new hires, but go down to front of the court right now and ask to talk to your caseworker and ask about all those files and make sure you understand everything.
And then another thing is, so I can go to the so my employer, so I can go to my employer to see like how I've been taking out my child support.
I bet it's coming. I don't know.
That's why I want to get to the bottom of that because I explained to you guys that
So Mr. Newsom, we have a child support order in 2 files.
Yeah.
This is their rearage file. The other file is a direct charging file. If they're taking child support out, it's going to that file, not this one. Even though you're paying her directly, you guys didn't let us know you were doing that. Do you understand that? Okay.
I don't understand.
So our case is arrearages only, the one we're here today on, because the child's over 18, right? Right?
Yeah, correct.
Okay, so this is arrearages only. Everything you go, it reduces the amount. You have a case with a child who is still a minor, so that is a direct charging child support case. All right, we have an order charging child support in that case because she's getting benefits through the state of Michigan, and those aren't free. So that's why that case got opened, right? So even though you're paying her directly, that's not being credited to that case. So you're getting an arrearage.
I've been paying her that money for like 3 years too.
Yeah, you probably got a heck of an arrearage on that file. So she's gonna have to write a letter and say that you have paid her $480 a month for 3 years and get that arrearage knocked down. But you need to go. You guys worked out an agreement. You just didn't tell us.
Okay, so I can do that.
Do you see where I'm at?
Yeah, I do see it. But see if she does that, she has to wear this down. Does she have to pay like extra money?
Does she what?
And she said that she agreed that like say I paid for $480 for the last 3 years. Will she get to pay? Like, so you got some of that money or some of that?
Well, we take like $37 a month for the health insurance. So you might, I don't know. I don't have the file. So you need to go talk to your caseworker. You guys can opt out of child support except for the amount owed to the state, which would be like 37 whatever a month. But you need to go talk to your caseworker.
Okay.
All right. Because if she doesn't give you a credit, you're kind of screwed for the last 3 years.
Okay, so I'm gonna go down there right now and check for it.
Yep. I don't think you did anything wrong. It's just confusing. So go talk to your caseworker.
Okay.
All right. So, but first I'm going to adjourn this. So I'm going to set this out to Ms. Adams. I'm going to need a notice of hearing from Mr. Newsom, October 7 at 8:30 in the morning. Okay. And we're going to get you a notice of hearing. Are you in your office, Ms. Adams?
Yes.
Okay, October 7 at 8:30 in the morning. So you have a seat right behind you, okay? Okay. All right. So it's okay. Thank you, Ms. Messer.
Thanks, Your Honor.
All right. So we are back to Michael Dagger Margosian. Let me get Mr. Olmsted. All right. So we are back on the record in file number 2025-22171FH in the matter of the people of the state of Michigan versus Harley Wayne Olmsted. Mr. Dagger Margosian is appearing on behalf of Mr. Olmsted. So have you had enough time to speak with him, Mr. Dagger Margosian?
I have, Your Honor. Thank you.
All right. And how would you like to proceed?
Your Honor, there are a few cases. There's only one case in front of you today, but I just want to address everything just to give the court some context on what's going to happen. Ultimately, Mr. Olmsted will be pleading guilty to the violation of probation in front of you today. We will get the sentence recommendation after that. He has a case in a felony case in district court that ultimately I'm very sure will result in a felony plea and a sentence agreement for 93 days jail and release to rehab. On this particular case at sentencing, I'll be obviously arguing for a concurrent sentence, but we can address that at sentencing. He will be entering a plea to the violation of probation today, with the understanding that the felony case will be brought up here to sort of tag along with that as well.
Okay, so we have a contempt of court for failure to appear for the show cause on February 11th. And then we have the probation violation, which alleges that he violated his terms of probation by failing to report on December 8th and January 15th. So December 8th of 25 and January 15th of 26, and his whereabouts were unknown. So he's going to plead guilty to both of those?
He will be pleading guilty to the VOP if the court wants to hold the contempt in abeyance. I think that would be a decent option. That's how I would like to proceed.
I could sentence them together.
It's fine.
So he'll plead to the contempt too?
Correct.
All right. All right. So, Mr. Olmsted, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. State your full name for the record.
Harley Wayne Olmsted.
Right. So, Mr. Olmsted, have you had ample time to speak with your attorney this morning?
Yes, ma'am.
All right. And you understand he's saying that you're going to plead guilty to the violation of probation and the contempt court for failure to appear?
Yes, ma'am.
All right. The probation violation is for a controlled substance possession less than 25 grams. What was it? It was fentanyl. That carries a maximum penalty of up to 4 years in prison if you plead guilty or found guilty. Do you understand that?
Yes, Your Honor.
And then the contempt of court for failure to appear for the show cause carries a maximum penalty of up to 93 days in jail. Do you understand that?
Yes, I do, Your Honor.
All right. Now, do you understand you have a right to contest this violation of probation charge and to have a trial on it?
Yes, I do.
Do you understand that throughout the trial, you will be presumed innocent until your guilt is proven by hundreds of the evidence?
Yes, I do, Your Honor.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions. You may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
I do, Your Honor.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
I do, Your Honor.
On the other hand, you understand that you have a right to testify at your trial if you want to testify.
I do.
How do you plead to the charge that you violated the terms of your probation by failing to report on December 8th of 2025 and December 15th of 2026? Guilty or not guilty?
Guilty.
All right, and that was mailed on January 20th. Oh, I'm sorry, December 8th of 25 and January 15th of 26. I have a proof of service showing this was mailed to your address that we had on January 20th of 26 and ordering you to appear on February 11th of 2026 to show cause. So did you fail to appear on February 11th?
Yes, Your Honor.
All right, and then it was because we didn't have a correct address for you?
Yeah, I was homeless, Your Honor. I was homeless.
Okay. All right. Do you understand by pleading guilty, you'll be giving up a right to a trial as Bert explained to you?
Yes, Your Honor.
Has anything been promised to you to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No.
Accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor, I do.
Is it your own choice to plead guilty?
Yes, it is.
All right, so, Mr. Olmsted, you were placed on probation. One of the terms of your probation dated August 11 of 25 is that you were to report to the probation department as often as required. Is that correct?
Yes, Your Honor.
All right, and you were ordered to report on December 8th of 2025. Is that correct?
I believe so, Your Honor, yes.
And you didn't appear that day?
No, that's when I became homeless. This was right before then, right after Thanksgiving.
Okay. And then on January 15 of 26 was your next report day, and you actually failed to report on that day as well.
Yes, I came back to Adrian and I was living in Ann Arbor.
Okay. And then the show cause we mailed to you was for you to appear on February 11 of 26. You became homeless. You did not report that to Mr. Stevenson, correct?
No, ma'am.
And then you failed to appear on February 11 of 26 as well for the show cause hearing. Is that correct?
Yes, Your Honor.
All right. So I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. So, Mr. Dagger-Margosian, I know you said he has a case down in district court still?
Correct.
Is that coming up here?
That will ultimately be coming up here, yes.
Okay. So, I have a sentencing date for this for August 7 at 8:15. Is that all right?
That's fine, yeah.
Okay. All right. So, Mr. Olmsted, I'm going to set this for August 7 at 8:15 in the morning. You do have a right to be present in person, or you can appear via Zoom. Would you like to appear in person or via Zoom?
Via Zoom is fine.
Okay.
In person, it doesn't matter, whatever works best for the court.
Okay. All right. So we'll do it via Zoom. So someone from the probation department is going to come speak with you. It won't be Mr. Is he back? I don't think it'll be Mr. Stevenson. It'll be somebody else, but they'll talk to you about the violation. They'll prepare a report. We'll get a copy to Mr. Dagger-Margosian. He's really good about getting over to the jail or meeting with his clients. But in the event he can't in advance, I'll give you a chance to speak with them that morning. Okay?
Yes, Your Honor.
All right, Mr. Olmsted, we'll see you back on August 7 at 8:15. Thank you.
Thank you.
Thank you.
Thank you. Is that it, Mr. Dagger-Margosian? No? Yes.
That's it for me, thank you.
Okay, thank you. All right, so Rhonda, it's just all you now. And let's see.
Want to start with Mr. Jakeway, Your Honor?
Yep, we can. I'm just getting down there. And no, there it is. All right, this is file number 26 or 2026-22700AX in the matter of the people of the state of Michigan versus John Robert Jakeway. This is the date and time set for a hearing on an extradition. So you are John Robert Jakeway, sir?
Yes, ma'am.
All right. And Mr. Jakeway, an extradition is a proceeding to determine whether you wish to waive your right of extradition. Extradition is a proceeding to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. Do you have any paperwork with you? Did they give you any paperwork?
Yes, ma'am.
Good. All right. It is in effect a demand by another state for your surrender and to return to that state to face the crime with which you are charged. So you are charged with out of Wood County, Ohio, with possession of drugs, count 1, and count 2, illegal use or possession of drug paraphernalia. One or both are a felony in the state of Ohio. You do not have to waive your right to extradition. You can require that the governor of the state of Ohio make demand upon the governor of Michigan for a warrant for extradition. You have the right to demand and procure legal counsel. If you cannot afford an attorney, we can appoint you one at county expense. If you or your attorney wish to test the legality of your arrest, you may apply within a reasonable time for a writ of habeas corpus. That is a writ by which your custodian is required to bring you before the court for the purpose of having a hearing to determine the legality of your arrest. Do you understand the rights that I've just told you?
Yes, ma'am.
Would you like an attorney appointed to represent you?
No, ma'am. I'd just like to waive my extradition so they can come and pick me up, please.
Okay, so you want to waive your right to extradition, to a writ of habeas corpus, and to an attorney, and go voluntarily to the state of Ohio to face the charges made against you in that state. Is that correct?
Yes, ma'am.
All right, did they give you a pen?
No, they didn't, but they told me if I needed one that I should ask for one. You want me to go get one real quick?
Yeah, you need a pen.
Okay, I'll be right back.
Okay.
Well, they all kind of get scheduled at 8:30. We might, I don't know what you do.
I don't know what that is.
Let me.
I have a writing utensil.
All right, so in the middle of that, right above certification by judge is a date line of 7/29 of 26 and a signature line. It's kind of at the middle. You probably have 3 or 4 copies. I'm going to need you to sign each one for me, please.
You don't teach.
Jordan, what do we do on Rosecrans? What do I do, what, Judge? Rosecrans? Rosecrans? It's page 5. That's. He's done. Oh, you
All
done?
fine. Yes, ma'am.
All right, hold on a second. All right, so Mr. Jakeway, raise your right hand. Do you swear that the signing of these papers is your free act and deed for the purpose of waiving extradition?
Yes, ma'am, I do.
All right, Mr. Jakeway, I wish you the best of luck. Thank you.
Yep, thank you.
Okay, so you said for a pretrial September 2nd at 8:30, and you reduced the testing to 110. No objection by C. Opposed.
Yes.
Okay, thank you. You're welcome.
All right, jail Zoom 1, who do I have? Female?
Chelsea Miller.
Yeah, all right, Ms. Miller, hold on. Shut a bunch of these jail rooms. All right, this is, I have 2 files, file number 2025-22424 FH, file number 2025-22425 FH, the matter of the people of the state of Michigan versus Chelsea Lee Miller. I have Rhonda Underwood appearing on behalf of Ms. Miller, and I have Isaac Sneed appearing on behalf of the people. Says the date and time set for contempt of court on file ending in 24 and pretrial on both. So, Ms. Underwood, how would you like to proceed today?
Thank you, Your Honor. I believe, Your Honor, Ms. Miller is going to accept the offer of the prosecution whereby Ms. Miller would plead guilty to count 2 of the 25 file, Your Honor, which is possession of a controlled substance less than 25 grams. Count 1 of that and the 24 file will be dismissed, Your Honor.
Mr. Sneed, is that a correct recitation of the plea?
I'm just reviewing the other file right now for the plea agreement, if there is one.
Background for the jail in the States.
What's that, Judge?
We're getting background
Yeah.
noise for the
Yeah.
jail.
So just to affirm the plea offer from November.
These are three weird 257, 327s, 26s. But he had I didn't realize he was in jail. I'll have to check that. It just said pending further action. Okay, we're pending further action. Good morning, San Francisco, where it's 7:30. Good morning, Long Island, where it's 10:30. Good morning. I'm not sure what time it is there. Hello, Pennsylvania. Yes, it's a beautiful day here in Michigan. As good as it gets around here. Good morning, Mr. Lowry. Good morning. I didn't realize you were in custody till just this minute. So let me take a look, see how long you've been there. You had a bunch of other stuff going on. Oops. I guess you've been in jail for 28 days. All right, these are three files in the matter of People versus William Eugene Lowry. That's you, sir? Yes, sir. And we have the newest member of the Casey Strong law firm. It's now called Strong, Bradshaw, and Fleeman. They changed the name. Anyway, did you put your appearance on the record?
Michael Rizzo, Your Honor.
Say that again?
Michael Rizzo on behalf of Mr. Lowry.
Okay, thank you. We met a couple weeks ago. I'm looking forward to having you come in and represent clients down here in St. Joe County. Mr. Lowry, you pled to 3 charges of allowing another to violate the motor vehicle code, which is a very strange plea offer. I think Ms. Strong pulled a rabbit out of a hat, but you had managed to get your driver's license back. And as far as I know, you currently have a valid license.
Yes, I do.
You have a number of other things going on, which is why you're in custody. But my intention, Mr. Rizzuto, is to give him time served and a minimum allowable fine on each of these cases. He already owes a bunch of money, and he was making payments in June till he got locked up. These are all state statute cases. I guess one is state statute and 2 are state statute, 1 is ordinance. Do you have an out date Not that I know of. All right, and 26436 ST. That occurred on February 26th. I'm going to order 28 days jail credit, 28 days. Concurrent with the other two cases, which is 26439 ST and 26728 OT. I have to assign the minimum fine of $125. You're already on a payment plan. I'm going to do this 3 times. The prosecutor still agreed to this, despite the fact that you kept driving all the time because you eventually got your license. And I guess that's the ultimate goal. So I don't have any quarrel with what they did here. I would not have probably given you 28 days in jail, but you're in jail and I'll give you credit for the time that you got and wipe out your fine, except for the minimum cost. These 3 add up to $375, but as I indicated, I really don't have much discretion in the regard of what the minimum allowable fine is. Those state costs are to be applied to everything. And the last one, the ordinance case from March 6th from Three Rivers is (26728 OT). I hope you can keep your license, same thing, $125 fine, concurrent with the other 2 cases. As I indicated, even though you kept driving all the time, I probably would not have given you 28 days. None of those cases have a bond in it. So there's no bond to apply. All right, 28 days credit, 28 days, and all 3 files run concurrently, and the minimum allowable fine of $125 per case, which will be part of the payment plan. I checked this morning, you were making payments in June. You made one on June 3rd, you made one on June 20th. They weren't big, but, well, one was big, but one was $20. I'll take $20.
Right.
You just chip away at it, all right?
$80 payment too, I think.
All right. Well, when you get done with this, keep working on that. All right, Mr. Rizzuto, we're good to go. And Mr. Lowry, best of luck to you. Thank you. That was pretty straightforward. Our other 1030 matter is, it's our only 1030 matter. Yeah. Well, I would be willing to start early, but I don't want to jump start in Kessler. Oh, that's also Mr. Rizzuto. I don't think the prosecutor's going to appear on that one, so. All right, well, when anybody's ready. All right. It's always a little problematic when you try to start early.
Nobody else is here?
No, but if it's a victim case, you have to make sure that the victim has an opportunity to be here and to be heard. So if it's set for 11 and you started at 10:40, that could be problematic.
Mr. Wood is here, apparently never here, so.
All right.
Deputies taken down.
And that's a sore point of mine. If somebody gets arrested for drunk driving, the jail staff should fingerprint them, and I should.
It wasn't like bouncing around and pick up water either. I don't understand.
It happens all the time, which is why we have our own live scan fingerprint machine.
Had a case of that a couple months ago. They won't let me give a quick lead on because all you have fingerprints and teenage.
So he had to go to the station and get printed?
And he had to go back to, because it was a state police case, so he's got to go to marshal.
Well, we credit to our court administrator. We probably had that for 10 years and other courts have inquired.
Which I don't know, why would they get so hung up on, it's got to go back to.
I don't know, and
you know,
I don't really like, I don't know. But it precedes Sheriff Spence, Sheriff Lillywhite, Sheriff Balk, Sheriff Lowry. It's been here since I got here. It's like, why aren't they in the old days, they had to do the rolled ink impressions and, sometimes it was hard to get fingerprints from a disorderly drunk. But anyway, we have it. So we have it. But in some of these, they don't know who they are. Especially if they're not lawful residents. They say they're so-and-so, they don't fingerprint them. They could be wanted for murder somewhere. I don't know the answer to it, but I've railed it.
It's kind of deep, but regular drug trafficking, I had a CDL, get all the way down to morning trial, and Jay Blair, prosecutor, my dad gets there, he said, "My parents are Jay, I don't know." He said, "Well," he said, "we're probably not gonna have a trial today." I said, "What is that?" Basis here for me. And that's not a thing. He does federal warrants in Chicago for interstate stuff.
So did you give him his retainer back?
No.
Yeah, all the hard work had been done. Yes. Well, Mr. Guthrie is here, and that's a state statute case. There is a complaining witness. Your client is here. That's an ordinance. No, your client's not here. Is here. The ordinance client, Mr. Kessler, is his lawyer is here. We could probably start that one. The City of Three Rivers number. Stephen Kessler, Jason Kessler. Why, are you looking for him?
Yeah.
No, it's a matter of public record. Oh.
Yeah, I think we're eviction. I mean, that's, if it was 1940s still, I understand that. That's really how keeping track of people's evictions and your record. You know, it's got to be
Yes.
a new way to do this.
Well, the last address we have from Mr. Kessler is several years old.
Stephen?
Yes. White Pigeon.
Yeah, that's what we got.
Well, there's a, well, there's more than, there's a number of, that's a very common name.
Seems like, wow.
Yeah, that's that White Pigeon address. Yeah.
Never somewhere else.
Well, as long as they show up for court, I guess it's all the same to me, where they lay their head, but, all right, well, we've got the live stream on, but we are just waiting for somebody to stars aligned to start a case. Have you seen Mr. Bush? I saw him. Yes. I can stop it. We're not really doing anything. I'll stop the live stream for a moment.
Well, August 20th, you have a full day trial. We could do like a 1:30 to before.
August 20 at 1:30. All right, could I get a notice of hearing for him? Okay, I'm gonna enter a plea of not guilty on your behalf. If you two can come up with an agreement and that day talk about it with me, that's fine. But otherwise, we will proceed that day with her here as well. So it'll be in person, August 20 at 1:30. You have a seat over at the end of that bench right there, and then we'll get you a copy of a notice of hearing, all right? Yep. And Mr. Rackett. This is file number 25-22497F.
Good morning. Are you Corey Michael Skillman Vidlich? How do you pronounce the last part?
Vidlich.
Vidlich, all right. You have filed a petition for a name change, and I'm required by law to ask you certain questions. Are you asking to change your name to avoid criminal prosecution?
Sir.
You're asking to change your name to avoid your just debts or creditors?
Sir.
You're asking to change your name for any illegal or inappropriate purpose?
No, sir.
Then I think it's just, you want to just change and drop the Skillman part and go by Corey Michael Vidlich, is that correct?
Yes, sir.
And that's to match your Social Security Administration. All right. And have you prepared an order that grants that name change?
Yes, sir.
We have the petition, and there should be an order that you have prepared as well. I'm going to draw a line here on the last page of your order that for you to sign off on, just because of the fact that I need you to hand that to him, if you will, please. That way you can, we'll have proof that you were here that day and you were approving the order. All right, I have signed your order and granted your name change request. You can get a copy of this a little later in the day from the clerk's office, okay?
Thank you.
2026, and Ray of Chance.
Yaros, come up, please. You will raise your right hand. Let's place you under oath.
You solemnly swear or affirm.
You have, are you Chance Curry? Is it Yaros?
Jaros.
Jaros, okay. Mr. Jaros, you have filed a petition for a name change, and I'm required, as you heard me, to ask you some questions. Are you asking to change your name to avoid criminal prosecution?
Yes, sir.
Are you asking to change your name to avoid your just debts or creditors?
Yes, sir.
Are you asking to change your name for any illegal or inappropriate purpose?
Yes, sir.
It's my understanding that you want to just change your name to simply Chance Curry, is that correct?
Chance Jaros Curry.
Okay.
There should be an amended petition.
All right, an amended petition. I'm looking at the original ones.
I have a copy if needed.
No, I haven't. So what you're wanting to do is to change your name from Chance Curry Jaros to Chance Jaros Curry?
Sir.
Okay. Have you prepared an order?
Yes, sir.
You'll submit that to the bailiff. And again, I'm going to ask you to sign on the line I've drawn there just to show that you have approved the order. I signed your order changing your name. You can get a copy of it a little later in the day from the clerk's office once they get the file back over there. Okay?
Thank you.
26. CB 112 Christopher Powell versus Ashland Mallett.
Ms. Collins is on Zoom. Ms. Carpenter, rather, is on Zoom.
Good morning, Your Honor.
We have a motion to withdraw.
Yes, Your Honor, we're going to strike that motion. I know we're set for hearing tomorrow. Does the court want my client present with the children in the morning?
I'm sorry.
I wanted to ask if the court wants my client present with the children in the morning. I think they're in Tennessee currently, the children with father.
I've been in Cheatham County for these, for the last several weeks. I'm going to look at this response that Ms. Roberts has filed, if I understand correctly.
Yeah, Your Honor, if I could just kind of briefly, I filed this petition. Parties have 2 minor children together who lived here in Dixon County, went to school here in Dixon County. Mrs. Mao got evicted from her apartment at the Trails and packed up and left and moved out of state. She unenrolled the children in school with a few weeks left, a couple of weeks left in school, and left. We filed this petition. It was filed on April 14th. We had her served out of state on April 23rd. I set a matter for a hearing on May 18th before Judge Lockhart Mash. I believe the evening before the hearing, I received an email from Ms. Carpenter stating that she had been retained. I appeared before the court because, again, the children have left. My client went to visit with them and got the police called on him there. So when Mrs. Mal appeared before the court on the 18th of May, she was placed under oath and had to affirm on the record that she had in fact retained Ms. Carpenter and paid her in this matter. And based on that, the judge continued the hearing. And we had a hearing on May 29th where Ms. Carpenter and I just reached an agreement where they were just going to do equal time during the summer. And it was set tomorrow. It is set for tomorrow because the children, again, as Your Honor's aware, Dixon County schools start on Monday. And so it is a matter that needs to go forward, and it's set tomorrow in front of Judge Lockhart Mash, and she's heard the other matters involved in that. So.
Well, wouldn't it be more appropriate for Judge Lockhart Mash to hear the motion to withdraw?
Well, yeah.
It's going to affect her hearing tomorrow.
Well, again, and that my position is if Ms. Carpenter has if there's been some violation of the attorney contract by Ms. Mal, I certainly don't think she should have to be an indentured servant and represent a client who hasn't paid her, or is not cooperating, whichever it is. I know ethically she doesn't have to disclose that, but she said there's been a breach of the contract. So as a result, if she wants to withdraw, certainly she has every right to do at that. But the hearing is set for tomorrow, and I implore the court not to give Ms. Mal any additional time to file count.
Well, it's not my hearing. It's in front of Judge Lockhart Mash.
And I have filed a motion for default set for tomorrow also.
Ms. Carpenter, I'm willing certainly to grant your motion to withdraw because obviously, as Ms. Roberts said, if there's been a breach of your attorney-client relationship, then you have the right to withdraw. But I am not in a position where I can continue a hearing in front of another judge anyway. So your client will need to be here tomorrow morning with the minor children for that hearing in front of Judge Lockhart Mash.
Your Honor, I'm striking the motion to withdraw. I just wanted to find out if the court wanted my client there in person. My understanding is the children are in Tennessee with father for parenting time currently. So I'm just asking if the court wants us in person tomorrow, which is fine.
Judge Lockhart Mash does not allow appearance via Zoom.
All right, she needs to be here because Judge Lockhart Mash does not allow the Zoom appearance. So If you're striking your motion to withdraw, then the matter will remain set for tomorrow morning at 9 o'clock in front of Judge Suzanne Lockett-Nash.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
2023 CV 195 Matthew Phelan versus Desiree Llewellyn.
Judge, this is our motion to dismiss for failure to prosecute. I think the case.
How are you doing?
Not real good today.
Well, it don't look like you're doing.
I think it's going to be Monday before I'm back at it, but
Anyone who's had surgery yesterday and shows up for court today has got to have a leather strap somewhere to chew on is all I can say.
I had one matter I didn't feel like could be reset.
All right, this is a motion to dismiss for failure to prosecute.
Yes.
You represent the respondent mother, Desiree Llewellyn.
I do. And over the history of the case, Your Honor will note that Ms. Roberts was involved for some time, and I would hazard to guess, just like she hazarded to guess a few minutes ago, Mr. Phelan did not cooperate in communications with her. We've sent this motion to him by email. We've sent this motion to him by mail, I believe. And we're just asking that it be dismissed for failure to prosecute.
Matthew Phelan. All right, case is dismissed for failure to prosecute.
Thanks, Judge.
Your Honor, while Ms. Dooley's up there, I have filed a motion asking. I request for
I think that would be appropriate. This is you and Ms. Duke.
yes, and Ms. Duke and I are involved in it.
And I didn't know if we could get a reset date on that while we're standing here.
Fine, I can try to give you one. What case is it? The Jones case?
Jones versus
Jones.
It's a Humphreys County case I agreed to hear here, right?
Yes.
And I just handed up to you an agreed order. Ms. Duke and I were able to resolve the real property issue, and we've signed an agreed order. I may have dropped that out. That's not, that, I think that's one of them up there. I was going to get you to sign, and I'm going to take it back.
And this is one that we did a really short reset on this one, just so that Mickey could get in touch
Can you hand this
with.
back, please, to Ms. Roberts?
The guardian ad litem is available. Move it, so we don't have her here, so.
If we could get 2 dates and then us just talk to her about it, I think we should be able to work
She's
it out.
downstairs in June. Today's her June.
I could probably give you the, how long do you think it's going to take?
It'll basically just be a custodial determination. SC agreement. Back to the home on Thursday.
I gave the children the home and gave your
Children
parents
the home.
visitation
We
with the
resolved
home.
that, and she's buying the home, we're gonna refinance it. My client's moved out, so it's an establishment of a residential establishment.
And Your Honor has heard quite a bit on this already. I think we probably won't go back behind the last order. I don't intend to. Ms. Roberts, I don't expect would, but so maybe over the last year, you'll hear testimony about that stuff.
Thankfully, all the kids are of age that they
I will repeat my question. How long do you think it's reasonably, realistically?
3 hours, I think, is a fair.
All right. Well, the reason I'm asking is I don't have any open dates for the entire month of August, but I don't really have any open dates in the entire month of September. Now, I have August the 18th, which I am scheduled for Houston County Chancery Court. And I talked to my clerk yesterday, and originally I had told her to take that day off because it needed to be, I was trying to give something to Chancery, but I could probably give you the afternoon of the 18th.
I had 2 days in August that I'm available, the 18th and the 21st. I have no other dates.
Right.
I'm in court every day
No.
other than that, so now I only have 1 day.
Where will we hear that?
Where you want to go? You want to go to my hometown of Erin to hear it?
That's fine.
You want me to come back here? I can do it at 1:30.
I think here would be great.
I think given the construction
Oh, that's right. Yeah.
house, that might be.
They're adding on to the courthouse there.
And you have to kind of get to the elevator. EDA scenario, you have to go down the steps to get to the elevator. And then get, so I would rather
All right.
do it somewhere where.
Well, I will let Ms. Brooks know that she has the morning, but that you have the afternoon, so.
What day of the week?
That's on a Tuesday.
Hopefully,
You want to double check with Mickey before
If
we,
she's not, then we'll circle back around. I have court with her this afternoon at 1:00. She is, and so in juvenile, I will check with her, and if that's not available, we'll get back to her.
now who has the Jones file?
I talked to Miss Abby. I told them that I wasn't going to bring it because I might be able to grant a motion to continue. I will text Miss Abby and tell her I'm not coming to get it.
All right. Do we have anything else set tomorrow morning? There's nothing other than Jones, right? Okay.
Ms. Roberts and I have a few matters, but we're working through those, getting those reset.
But those are from Judge Locker Mash.
Yes.
All right. Is that all you had, Ms. Duke? Call the next case.
2025 CV 55, Bruce Green versus Connie Lumpkin.
So this is here on my motion to either compel Ms. Lumpkin to sign, to appear at the closing, or in the alternative, ask the court to allow me to enter an order divesting her of ownership of the property, investing it with Mr. Green for the sole purpose of concluding the closing on the sale of the properties. This is a case, Your Honor, wherein I filed a previously involved. They purchased 2 vacant lots together. There has been significant amount of litigation in General Sessions Court, and then in Circuit Court on this matter. So we had to file a partition suit here, Your Honor, granted the partition via default. We appeared before the court, got an order to sell the property by auction. Mr. Neil Trice effectuated the auction. It was sold, and we came before the court on March 23rd of 2026, and you approved the sale. The closing has been set. Ms. Lumpkin has failed to appear, has failed to file anything, has been served with this, is not present in the courtroom, has never appeared. And so I would request, Your Honor, I'll put on Mr. Green to verify what I have advised the court, and we would just ask for an order divesting the property with him for the sole purpose of him executing and closing the 2 contracts for sale on the property, and that all proceeds be deposited into the court after the cost of the sale, which you've already approved in the court order, and then have Ms. Lumpkin come before the court. The alternative process is for me to file a contempt petition, her to be jailed until she signs it. I do not want to do that. I think this is the most expeditious way to get this matter closed and the money paid into court.
All right, Mr. Green, raise your right hand. Let's place you under oath.
Do solemnly swear or affirm
You are Mr. Bruce Green, is that correct?
Yes.
Mr. Green, during the time that you and Mrs. Lumpkin had a relationship, y'all purchased 2 lots out on Furnace Hollow Road, is that correct? There has been a significant amount of litigation downstairs in General Sessions Court. It got appealed. It's in Circuit Court. Mr. Potter represented her. We went through a number of things. We were able to resolve that, but y'all still ended up owing those 2 pieces of property together. Attempted to negotiate with her to get that taken care of, all failed, correct? We filed a partition suit, served her, and she failed to appear or file an answer. And we took a default judgment, and we came before the court to sell the property by auction. We retained Neil Trice to do that, and he effectuated that and sold both pieces of property by auction. Is that correct? That's correct. We came before the court, presented the sales price, and this court approved the auction. The closing was set. You appeared to get everything and signed everything. You have a contract pursuant to this court order, 2 contracts that need to be closed out. Right?
Yes.
And you understand what I'm asking the court, what we're asking the court is for you to be vested with the property for the sole purpose of you signing the deeds to the new purchasers. And the funds will be deposited with the clerk and master, and we'll have to come back another day to decide how it's going to be divided. And you're asking the court to do that. And again, we discussed the option of filing contempt and doing that. And again, this is the most expeditious way to fulfill your obligation under the contract that you signed.
All right, I will grant your request to authorize Mr. Green to solely be able to execute the deeds necessary to close on the sale of this property.
Thank you, Your Honor. I'll get the order over.
2019 CD230, Michelle Santiago versus Fernando Santiago.
That is a show cause order. I've actually, it's amazing how a show cause order can get someone's attention.
Turn that microphone just.
It's amazing how a show cause order can get someone's attention, a motion for show cause, that is. I have been in touch with them and they are working on it. The lady is out of town this week, so if we could just pass that to another date. I don't know what dates it really does not matter what date.
Doesn't matter what judge, we can give you the next, how long away do you want it?
Instead of
So August the 26th.
the 26th will work just fine.
T25 CD289, Michael Thomas versus Rachel Thomas.
Good morning.
Morning, Judge. We are here today. We've got a couple different motions that are on this document. And my client should be on video.
I've admitted her. She needs to turn on it. There she is.
There she is. We've got a couple different motions on the docket today, Your Honor. I think it probably makes the most sense to deal with the motions that I've filed, which would have been for the interlocutory appeal and the motion to stay proceedings based on the fact that it's going to be filed under Trap 9 through the Court of Appeals. We came here previously and the court said at that time that should an interlocutory appeal be sought, that the court would approve that. We now are asking for that interlocutory appeal formally, which I think under the rules I have to do at that point. And additionally, we are seeking the statement that the Court of Appeals requires of the trial court in terms of what is being appealed and why the court believes that it's necessary.
What if the judge who's granting the interlocutory appeal thinks he made a well-reasoned and informed decision that the Court of Appeals would certainly uphold, but you are saying I need to draw an order that, or a statement for the appeal according to the rules? That is what is said.
Correct.
This is a case clearly, and do you want to respond to any of that? So.
Judge, I would like to respond on the motion for stay. Certainly, I don't think a stay is appropriate in this case. This court's already held that it's got jurisdiction. That order is in effect currently, and that order is going to be in effect until and if the Court of Appeals overturns that order. And that's an if that happens. So I don't think a stay is appropriate in this matter. If the court is inclined to grant a stay, I think that stay should only be applicable to baby Thomas that is in Colorado. We have 2 minor children here. Scarlett Thomas is still with mother in West Virginia. The appeal is solely related to the court's exercise of jurisdiction over baby Thomas. So if the court's inclined to grant a stay, I think that stay should only be applicable to baby Thomas.
And I didn't touch on the stay. I was going to take those as 2 separate aspects of it because I think those are 2 separate aspects at this point.
All right. It is this court's opinion that and what I stated before, this is one of the more unusual cases that I've had come before me. This is a case where, based on alleged domestic violence, which I'm understanding from Mr. Kirby, that Mr. Thomas has either pled guilty to or been found guilty of some sort of domestic violence in the past. And that led Mrs. Thomas to relocate to the state of West Virginia with the party's 1 minor child. But she was pregnant at that time, if I recall correctly, and gave birth to that child and then placed that child for adoption with a couple in Colorado, and that there is a Colorado court exercising jurisdiction over that child, or at least attempting to exercise jurisdiction over that child. Mr. Kirby's argument is that child, that this court does not have jurisdiction over that child I am of the opinion that this court, once I assume jurisdiction over the divorce between the parties and any minor children that the parties had, that this court has jurisdiction over any child that is born during the pendency of that divorce action. And for that reason, I am of the opinion that this court is the appropriate venue for all matters concerning the minor children. The Mrs. Thomas, through Mr. Kirby, is asking for an interlocutory appeal on the issue of whether or not this court, solely on the issue of whether this court has jurisdiction over the minor child born to Mrs. Thomas and Mr. Thomas, because the DNA test results have shown he is the biological father. And if you are asking for an interlocutory appeal, you understand, if I grant the interlocutory appeal and state the reasons why, it still is up to the Court of Civil Appeal to determine whether they'll even grant that.
Correct.
So a stay as to that child would simply stay this court's exercise of jurisdiction over that child. My concern is whether or not that means that the Colorado court will continue to proceed with the adoption proceedings in the state of Colorado, because if what I don't want to do is grant your request for an interlocutory appeal and then issue a stay order on this court's exercise of jurisdiction over the newborn child that allows the Colorado court to say, hey, we've got jurisdiction because the Tennessee court has stayed that in its own appeal, and that gives them somehow a leg up. That's, I think, would be unfair to Mr. Thomas in that regard. So how do you address that? What is the status of the Colorado proceeding?
The last time, and I've been in communications with the attorney for the petitioners in Colorado at this point for the adoption, they are still going through the jurisdictional argument aspect of things in Colorado as well. The petitioners had submitted their brief on that. I believe that on behalf of father, husband, there was a petition or a brief that had just recently been submitted. There's been no ruling in terms of that in any way. My understanding is that there's not any sort of final hearing that I've been made aware of that is set on that, because they are still going through the base level of, do we have jurisdiction and what are we going to do with that? As far as the concern that the court has, it's a valid concern, obviously. I think there's two things I would say to that. One, we already knew that Colorado was going to do what they were going to do anyways. And this isn't giving up. Sorry. This isn't giving.
Your time is up.
Apparently. This isn't giving up. This is not the court saying that you are giving up jurisdiction under your ruling. This is us simply saying that we need to make sure that this is happening. We're trying to be judicially efficient about it, make sure that there's a uniform body of law, do all the things that are laid out for the reasons that we go under the Trap 9 appeal in the first place. I also believe that it would be appropriate to put into an order to stay that this is, again, not giving up jurisdiction under your order, and that it is not giving free rein to Colorado to move forward, as you still believe that you have jurisdiction pending any ruling by the court.
Your argument that this court lacks jurisdiction over the newborn child has been based on the fact that the Uniform Child Custody Enforcement and Jurisdiction Act says that child never resided in Dixon County, and for that reason, it is not this court's jurisdiction, even though I have asserted jurisdiction over the parties and asserted jurisdiction over their other child. And my response to that has always been that to follow that argument, that it would defeat this court's jurisdiction for any person like the mother to take a child, or if she's pregnant, to leave the state during the pendency of any custody action, and thereby defeat a father's right to have the court that's hearing his divorce action be able to, adjudicate the custody of all of the children, including the one that was born out of state because the mother left, which is exactly what we have.
And I think to respond to that, Your Honor, there's also a separate statute within the UCCJEA. I believe, if I remember right off the top of my head, that is Tennessee Code annotated 366223, if I'm not mistaken, but please don't hold me to that. But essentially, the statute says that jurisdiction cannot be placed somewhere else if it is done with unclean hands, essentially, that it is done with the intent of trying to go through and
Which Mr. Thomas would argue is exactly what your client has done.
But it's really not, because we came here before the court. She requested to go there. She requested to do those things. Everyone knew that she was pregnant at
You
that
didn't
point.
request to take the newborn child to Colorado and give it up.
That's a separate issue altogether, because my statement is that West Virginia is the home state of the child based on the child being born in West Virginia, and anything that happens in West Virginia after that, that's in West Virginia, and that's a West Virginia problem, and that's something that needs to be sorted out between Colorado and West Virginia.
So that argument, Mr. Thomas would have to then retain counsel here in Dixon County, also retain counsel in West Virginia, and also retain counsel in Colorado, which I think is not what I believe would be the effect that the law has in mind. So I will grant your interlocutory appeal request simply for the basis that this is an unusual situation, and there is the implementation of the Uniform Child Custody and Enforcement Jurisdiction Act brings before the court issues that are not normally in one of these cases, and I'm required to make a finding as to what the issues are. So my suggestion would be that I will draft the order, but I'm going to give you both 10 days to submit to me your proposed issues that you believe require an interlocutory appeal, and then I will draft, using your both suggestions, I'll draft the order that I think is appropriate for it, but I will grant the interlocutory appeal solely as to the newborn child. And I will not grant the stay of the proceedings as to the child that was born during these proceedings or while they were living here, because I don't think that the uniform commercial, why do I keep saying that? That was my least favorite class in law school, was the uniform commercial code. It was the most.
We had a teacher that just read from the book the entire time.
Well, when I was in the University of Houston Law School, I know you really want to hear this. We had the guy who actually drafted it. He was like 110 years old, and he was from Harvard, a visiting professor at the University of Houston Law School. And all he did was sit and talk about going to lunch and what over lunch they talked about this provision. 50% of the class dropped it, including myself, dropped it because we were convinced that we weren't learning anything about the Uniform Commercial Code. I have never regretted dropping that class, nor do I ever want to know anything more about it. But the Uniform Child Custody Enforcement Jurisdiction Act, I think, is the key here, and that's where you need to focus what your issues are. So 10 days for each of you to submit the issues that you think need to be adjudicated by an appellate court. I will then draw the order, and if you will also submit an order granting the interlocutory appeal, and I will sign that after I've submitted, at the same time I submit my written statement of the issues.
Understood. And for the record, I previously filed already an appeal through the Court of Appeals in terms of giving notice. That one's, and I've spoken to counsel about that. It was filed under Trap 3 instead of Trap 9 because I, for lack of a better phrase, fat fingered it when I was trying to put it through. It's led to the wrong thing, but we're still within there because I've got 10 days after that order is signed. Right. So that won't be dismissed. There will be a Trap 9 put in place.
That's between you and the Court of Civil Appeals.
Exactly. I just want to put it out there on record that one's going away for that purpose.
All right. If you will send those directly to my office, please, and then that will be helpful. If you want to send them to my email address, you can do that if you'd rather do it that way, whatever you want to do. Do you have that email?
I don't know that. I don't do.
I'm going to give it to you, but I'm not going to announce it over.
You don't want to put it on record for the YouTube watchers?
Yeah. You two are going to have to share. I only have one.
I'll take a picture of it, Judge.
Yeah, I was going to say, I'll take a photo of it real quick.
Just to be clear for the record, so the court is granting a stay with respect to any proceedings regarding baby Thomas in Colorado. We do have set today an evidentiary hearing on the father's motion to return the minor children to him.
And that's set today?
That is set today. I would ask that that go forward on the basis that the court's still exercising jurisdiction over Scarlett Thomas, the other minor child. The father has witnesses here. We're prepared to move forward on that motion. Also, the motion to reduce his spousal support obligation is set today. And we're prepared to present testimony and evidence in regard to that. His father was paying $1,500.
Well, I'm not staying the proceedings, so as to that child
And if I may, Your Honor, to give the court a little bit about the next steps there, because I don't want to have any surprises. I understand what this court is staying at this point. I may very well file through, if the appeal is accepted through their interlocutory appeal, which I believe that it will be, then I have the opportunity to also ask for a stay through there as far as both children, which we probably will. So I'd ask for time to do that because I have not been able to do it so far. I'll also point out to the court that
let me repeat what you're saying. What exactly are you telling me? That I've granted your stay as to the newborn child. Now you're saying that you may be requesting a stay as to the other child?
Correct. My request.
You haven't filed anything such as that yet, right?
I've not been able to because of the fact that we need this stuff from the trial court before I can do anything through the court bills. There's not anything there at this time. I did request through the stay here with the trial court for it to be with all children. The reason being for that is because I believe all the evidence that we're talking about here, the purpose for doing the stay is to make sure that we're being as judicially efficient as possible for everyone. And all of the same information we're talking about is essentially going to apply to both children. I'll also say that the motion that's been filed was an ex parte that was denied. And the ex parte relief that was requested was essentially as it related to baby Thomas, that we'll say, which is part of the Colorado. There's nothing there that has any sort of issues for mistreatment or anything along those lines as far as the child that is in my client's care and custody, that she's got the order of protection that is currently there. She has the agreed order that was submitted saying that she went to an undisclosed location for reasonable fear of domestic abuse. I don't believe that any of the situations to do with what's been filed truly relates to the child that is in West Virginia at this point anyways.
Just for the record, it wasn't an ex parte motion for return of the minor children. It was just an emergency motion. Father had found out that the mother had placed the child up for adoption in Colorado. He has not had contact with Scarlett Thomas, the newborn baby Thomas, or the mother in over a year. I understand Mr. Kirby's argument that that's his own doing with respect to the order of protection. The order of protection does not, however, include the minor children. Father has gone over a year without any visitation with these minor children. In his motion for the immediate return of the minor children, he prayed for general relief. The court set this hearing to determine if the father was going to be awarded any parenting time. We're prepared to move forward on an evidentiary hearing. We're getting into a situation, the longer this goes on, the more irreparable harm it's going to create the father's relationship with these minor children.
On the flip side of that, we've got every single statute because the parties cannot communicate things to an order that was granted and has since been appealed and is still in full effect at this point in time as an ex parte, and is not set to be heard at then that does not diminish father's ability to come back at a final hearing. The court is not to consider anything for temporary. So I don't think that it's going to be unfairly biased against him. And again, the statements that were there, I believe the only statement that was there as far as the child that's in West Virginia is that father didn't know if she had also put that child up for adoption, and I'm stating on record that she hasn't, and there's no intent to. And last time we were here.
So let's just separate the two because you keep telling me that those two are separate issues. So let's just disregard the issue about the child in Colorado. We have a father who has not seen his child in West Virginia for over a year. And why would I not allow him to proceed with a hearing today that's been set by notice or set by court order properly? Why would he not be entitled to go forward today with a hearing regarding either an order returning the child or at least establishing some sort of visitation between him and that child? What what legal principle would allow you to stop that from happening?
I think the legal principle I would rely on is the fact that I think the court's probably not going to agree with me.
I don't think I'm going to agree with you either.
No, but the legal principle I'd be relying on is the fact that everything to do about what is going to be there for, I'm going to say, additional efficiency. Are you having to expend more time, energy, resources, financial resources?
Well, I'm going to cut you off, Mr. Kirby, because in my opinion, it is manifestly unfair to the father, Mr. Thomas. And I know nothing about him. I mean, I know what's been alleged. And I think this is a case that I set for an evidentiary hearing to determine what is the situation between these parties, what has happened in the past, what are the conditions, like any other child custody case. And I'm going forward with it today. Now, I will pass this case to allow you two to talk about it, but we're going to come up with some sort of a way for Mr. Thomas to have some sort of contact with these children, with this child. It's just a question of under what circumstances, what safeguards and so forth that are going to have to be done. But I have some other matters that hopefully will not take as long, and I expect that we'll have to have a hearing. It'll take some time for your case. So we're going to pass you on the docket and come back to you in a little bit. Your client's on the Zoom. She can stay, and I'll just put her back in the waiting room, and you can talk to her and be prepared for that hearing.
Thank you, Judge. We'll talk in the meantime.
All right.
Thank you.
Thank you. All right, call the patent.
2022,
Good morning, Your Honor.
Good morning. Mr. Patton, it's my understanding that you have declared bankruptcy, that some notice has been given. Is that correct?
That's correct, Your Honor.
And that basic of your bankruptcy, you've included the real property that I made a ruling on in this case?
Correct, Your Honor.
Based on the bankruptcy laws, and I'm foreclosed from doing anything regarding the real property that's included in your bankruptcy action.
Your Honor has already ruled that that real property is Ms. Patton's.
Agreed.
And he is holding a necessary insurance check that Your Honor has already said was awarded to her. This divorce has been completed for some time. Real property was awarded sometime. He's tried to backdoor it by filing a lien in the Register of Deeds office. This real property is fraudulently being placed into the bankruptcy court, and it should
That's
not
for the
be.
bankruptcy court. I agree with you. I agree with everything you've said. He has no basis to include this real property in a bankruptcy action. But a bankruptcy court is the sole judge, the sole area that allows for the for the determination of whether the asset that is alleged to do that. So Mr. Patton is treading in very thin ice with the bankruptcy court, because likely the bankruptcy court is going to find, as I have ruled, that he doesn't own an interest in that property. And as a result of that, he has attempted to defraud the bankruptcy court, in my opinion. And I think that the bankruptcy court will need to have an opportunity to determine that, because there's an automatic stay on any proceeding involving property that's alleged to have been included in a bankruptcy action until that bankruptcy court does that. But it doesn't stay this court from finding Mr. Patton in contempt of this court for failing to abide by this court's orders. You have not filed a motion for contempt, but I expect that's what you will do next.
That is what I will do next. We found out this notice was shoved into the door at my office in the middle of the night last night. So we've just found out about it this morning. The notice of bankruptcy. So That being said, I did want the court to know about the lien. He is still holding that check hostage. And he has filed some motion to have me disqualified as counsel because his girlfriend has some sort of relationship with Hidden Valley Properties, which our office represents, which is.
Let's hear that motion first.
Okay.
I'll allow him to argue that motion. You filed a motion to disqualify Reynolds, Potter, and Reagan and Vandervoort. You drafted this personally, did you, Mr. Powell?
Yes, I did, Your Honor.
Okay.
So at this time, Your Honor, I am preserving my motion to disqualify under Tennessee Supreme Court Rule 8, RPC 1.7, 1.9, 1.10, based on overlapping representation and confidential information concerns.
All right, I'm here. Anything you want to say?
I mean, I would like to preserve that for a future.
Reserve what?
The motion to just.
Now we're going to go forward with the motion for disqualification today. So you can argue it and I'll rule on it. Tell me why you think that this relationship that you set forth with Mr. Vandervoort being the attorney of record for a realist from some sort of Hidden Valley Lakes or whatever.
Okay, Your Honor, regarding my motion to disqualify, there's a severe conflict of interest that breaches attorney-client confidentiality. Ms. Duke's firm represents Hidden Valley Lakes and its president. I volunteered there, and highly sensitive and private details regarding my active divorce were directly shared by this firm, or with this firm, by the president and Mr. Vandervoort. Opposing counsel has access to confidential information that can be obtained through that representation, and that creates prejudice against me with regard to the divorce matters that completely undermine the integrity of these proceedings.
All right, I've considered your motion to disqualify and I've reviewed your basis for that, and I find that there is no basis for disqualification of Reynolds, Potter, and Reagan, that the basis that you have set forth would have no effect upon this proceeding, nor would it have anything to do with Mr. Duke's representation of Mrs. Patton. Was there any other motion that needs to be dealt with today? Ms. Duke, I want you to draft an order that this court finds, as I have previously found, that this court has previously ordered Mr. Patton to execute the deed to this property as was ordered originally in the divorce decree, that he has been. The notice of lingua pendis. So that would be a situation where this court would have to deal with that, but I think the bankruptcy court is going to have to deal with it. But I will stand by the order that the court has made regarding the check that was from the insurance company, because I believe that was part of my earlier ruling, that he has 5 days to execute that check. And if he fails to do so, I will hold him in contempt. Mr. Patton, I think you're playing games with the legal system. I think you are attempting to try to divert or to avoid this court's rulings previously. I don't think you have any basis to include that real property in the bankruptcy action that you filed. You are getting some bad advice. And I'm telling you right now that that bad advice from whoever it's coming from, whether it's your girlfriend or some other person, whoever's giving you advice on how you can subvert and get around this court's rulings regarding this case is giving you bad advice. It's going to likely end up in you being incarcerated in jail. I don't want to put you in jail. I want you to comply with the court's orders, but I'm not going to tolerate you playing games. And I don't think the bankruptcy court's going to do that either. And so you might get prepared, because I think the bankruptcy court, when Ms. Patton hires a lawyer and they proceed in the bankruptcy court, they're going to take a dim view of you attempting to use that process. Anyway, that's the order of the court. You may step aside. You may.
So, Your Honor, I had two other things that I'd like to discuss if possibly.
What are those?
So I would like to be on the record. I'd like to preserve that the deed was recorded before the written order was entered under Tennessee Rule of Procedure 58. A judgment is effective only when written and entered. And third, the deed acknowledgement is defective because I was never personally before a notary. And then, like I said, I asked that the property issues be continued. As far as the check, I have no knowledge of where that check is or where it's supposed to be. Ms. Duke told the court that it was at her office, and I agreed to go sign that check at the office. She later told me that it had been mailed to somebody or somewhere. And at that point in time, I have no knowledge or receipt of this check, Your Honor. So it's not a matter of trying to get around not signing it or avoiding it or anything like that. I have no knowledge of where this check is, and I've not been requested by Ms. Duke to come to her office and sign for this check.
Judge, we have confirmation and tracking that it was dropped off at Mr. Patton's home. And I can't control where the insurance company sends a check. I represented to the court that as they had told us, they were going to send it to my office. They did not. We've got tracking to show that it was sent to his house. He knows he has it, and he's refusing to provide.
Once again, Your Honor, I do not have the check, never received it. If it was mailed to the house, it's not in the house, so.
Ms. Duke, this court will order the insurance company to issue that check in your client's name only and to issue it directly to your office. And by order of this court, I'm directing the insurance company to issue the check solely to Mrs. Patton, and because she is the true owner of the property, and it's to be issued and mailed to your office, sua sponte. Secondly, your request regarding, or your objection regarding the deed execution is overruled and denied.
Understood, Your Honor.
And I will point out the original order trumps everything.
This court ordered it from the bench. And it's just like any other order in this court. If it's not in, even though it may not have been a written order at that point, you were ordered to do certain things and you did them. So it doesn't matter if you signed the deed because I ordered you to do so, then later saying, well, that order hadn't been, the written order hadn't been entered, is an attempt to, again, subvert and get around what this court says. Why would you object to the order being, why do you even object? Tell me why that is.
Because I've filed a motion 60.02 to contest this whole process, Your Honor. So it's been under contest since I filed my motion 60.02. And then Your Honor ordered me to sign a quitclaim deed over on the 10th, or excuse me,
I'm
15th.
overruling your objection to the deed because of the fact that this court is of the opinion that you did so in compliance with the court's order. Your Rule 60 motion will have to be heard after the bankruptcy court deals with you.
Well, and it was in compliance with the final decree. So it even goes back that far.
There is nothing in the decree that states that I am to sign a quitclaim deed, Your Honor, and give up my rights to a $150,000 debt. It's attached to a $150,000 debt.
Right. I've made my rulings.
Understood.
Thank you, Judge. I'll submit an order.
CV 77, Claiborne versus.
Good morning, Your Honor.
Good morning.
Mr. Guerin stepped out. I think he was sitting on the side.
I'm sorry.
I believe Mr. Guerin stepped out. It's his motions.
All right, well, we'll take a short recess and let him come back in. And once we do that, we'll deal you first, and then we're going to go back to the Thomas case.
Thank you, Judge.
We'll stand in a short recess.
final order that Your Honor entered was, at least according to the certificate of service, wasn't sent out until June 4th of 2024. And then Your Honor entered it, I believe, on June 18th, which is well past the 20-day local rule for submitting the order. I've reviewed the file, and if I don't think I'm mistaken, but maybe I am, I did not see any other court dates between that October 31st, 2023 hearing date and the date that Your Honor entered the order. At least based upon my review of the file, I didn't see any motions filed or any pleadings or anything occurring.
My recollection is there were no other court dates, that Mr. Holly had submitted an order that I didn't agree with the wording of it, and I declined to sign that order and instructed him to redraft the order with what I thought was the appropriate language, and that took some time to do, but that's why it was not, there were no court hearings in between. It was just a matter of me reading the order, disapproving the language that was used in the order, and then asking them to redraft it with the order that I thought was appropriate.
Okay. Well, that order does have a certificate of service on there, and those addresses and email address were not good contact info for Ms. Childress, so she never received the order, despite a few times after the hearing date she called up here, called the clerk's office to get a copy of the order, and she was told every time that you just have to wait on the order to be filed. She only learned of the order after being served with the capias some almost 2 years later. We're now about 3 years out from where the order was filed. And all these items that are listed in the order for her to return, some of the stuff Mr. Claiborne has been reunited with. There's really nothing in the record to suggest that Ms. Claiborne, Ms. Childress still has these items. There's nothing to suggest that she has this $42,000. I understand it's a civil contempt, but she has to have the ability to purge herself of this, and there's nothing to show that 3 years later that she currently has the ability to purge herself of this contempt. So basically what we're looking at now is basically a debtor's prison. She doesn't have the ability to purge herself, which there's nothing to show that 3 years later she now does. It's become punitive. And because of that, Your Honor, I would ask that the court alter its order or just enter a new order to release her, to show that she's, she's been in jail, 4 months now. The appropriate remedy for Ms. Childress would be to release her from custody. So I'd ask that you grant our motion, modify her sentence to 10 days, and to release her time served from the Dixon County Jail.
Ali, you wish to make an opening statement?
Yes. So I remember that we did have some court dates kind of after that October date, Judge. I had put together, and I've given a copy of it to Mr. Guerin. This really is nothing.
You may be correct. This has been, that order was from a hearing in 2024. And as a result, I'm not sure that my memory of it would be as clear.
I've shared this with Mr. Guerin. We talked yesterday, and then I gave him a full copy of my timeline today that's got everything attached to it. I tried to streamline this because this file is rather voluminous and different orders and things flying around. But this is all the orders, the motions, the things that I felt like were important to and germane to our issues here today. You look at the timeline, there was a 2/15, February 15th, 2024 court hearing, and what all led up to that a little bit. And then there's also a June the 4th hearing on the motion to approve the order. And we did have those other two court dates. I had lodged an order with the court. And again, the court had some issues with the order, wanted some amendments. And we had that February 15th hearing, which I sent a notice to Ms. Childress at the two physical addresses and her email that I had. And we had that hearing, and the court instructed me on what to do on the 15th of February. And then there was another change on the 4th of June at our hearing there, and then I submitted an order that the court signed on June the 18th. So this court took special care with this order. The first order I sent in, I mean, I did it like I do the civil contempts and whatnot, jailed indefinitely. And the court said, no, you didn't want that. You wanted a provision in there for her to have 6 months of incarceration and to be let out after that. So she was not jailed indefinitely. And there's some other things in there too that this court did that, again, taking careful consideration with the order that you did. Our position today, Judge, is really one of a few things. One, I've filed a response in opposition. If we're going to oppose this, obviously, I think the court, I can get into the argument on that if the court wants, but I think the court took great care with this order. I don't think there's anything that's inappropriate with this order. If the court will remember, it was a fairly egregious situation where she had gotten a domestic assault on Mr. Claiborne, got control of the house, and basically ransacked the house. There were, and the court heard hours of testimony about defecation in drawers of Mr. Claiborne's clothes, urination on the furniture and the beds and things of that nature. There was a lot going on at that time. And Judge, basically, we are asking that, number one, if we're going to go forward with the motion to alter or amend, that be denied. I think the court did what the court was supposed to do with that. Number two, let her out of jail with some stipulations. We're fine with that. You know, she's here today basically wanting to get out of jail. That's what this motion is about. What we're about today, Mr. Claiborne just wants what's due him, what his justice is out of this order that the court did. Either his stuff back or the money paid, and we've already beat that horse all the way around the track, and there's an order down for that. But we say she's, got some time left on her 6 months. Let's stay that, or however the court wants to do it. This is contempt, and the court has the absolute range, in your hand to do what you want to do here. You're driving this bus. Let her out of jail. Let's reset this maybe to the 1st of December. Give her a little bit of time to either make some payments, get this stuff back. Let her know that this is a serious matter. I don't know if she understood it was this serious, but let her know it is a serious matter. And let's come back in December and see what she's done and it's up to the court then to do what the court wants to do, to see what her conduct was during this period of time. We're not getting any satisfaction here seeing her in jail. Mr. Claiborne wants the return of the property or his money back. And at that time, there was a present sensibility for her to be able to return this property. The court found that. It's in my response. And I'll be glad to go over the response and argue this in detail if we need to. But at this time, we're fine with letting her out. But put a few stipulations on it that we've got a reset date. I may want to file some interrogatories about her. We think maybe she's gotten a settlement, some things like that. We want some sworn answers about that, and either continue this motion to alter, amend until then, or do whatever the court wants to do. But we're fine with that as well. That's, I think, probably the preferred remedy for Mr. Claiborne, to be honest with you. So one of those two is what we're requesting. And again, I'm a little in the dark here as to what we're doing. If we're arguing only the legalities of this, I'd like some more time. If we're calling witnesses, obviously that's up to Mr. Garrett, it's his motion. But if we're calling witnesses, I may call some witnesses, especially Mr. Claiborne, to contradict some of the things. But by and large, if we're going to argue this legally, I'd like to have opportunity basically to argue it legally. But those are, as far as my opening statement goes, that's what it is. Thank you.
Well, this court considers this situation to be similar, if not exactly like a father who has not paid his child support and has accrued a large arrearage of child support under a court order and then fails to comply with that. Then there is a remedy that's given to the court, and that remedy is for civil contempt. The first order that Mr. Hawley, I think, drafted, if my memory serves me, included language that she would either return all of these items or pay him the amount, or she would be incarcerated indefinitely. And I think that was the part that I objected to, because under the law, I can only punish someone by giving them jail for 6 months at a time for civil contempt, but I can do that twice a year, as has been pointed out in in child custody cases. But even in the most egregious child custody cases, what happens is you give someone an opportunity to see what it's like to be in jail so that you can hopefully motivate them to come in compliance with the court order. Civil contempt versus criminal contempt. Mr. Guerin makes the argument that this case has transitioned from civil contempt to punitive and therefore criminal contempt. And that's his argument that she's could only be punished by 10 days in jail for criminal contempt. But this court disagrees with that because under the circumstances, this court heard this case over many, many different court dates. And there was an egregious set of facts in this case. There was a short-term marriage, and sometime shortly after they had married, Mrs. Claiborne got an order of protection against Mr. Claiborne and dispossessed him of his own house, the house that he owned prior to their marriage. The evidence at the trial was that the house, when he left it, had numerous items of personal property that belonged to him and his late wife, and that during the course of the time that he was out of the house, that Mrs. Claiborne had visitors, a number of visitors and parties and things at the house, that the next door neighbor testified that and took pictures of parties at the hot tub behind the house and different things that were going on like that. So when I ordered her to vacate the house, because it was his home, on a temporary hearing, then she vacated the house. But the testimony was that numerous items, a great number of items were removed or damaged, and that, in fact, what was more convincing to the court than some other things was the fact that there was testimony that the drawers of the dresser in the bedroom had been removed and feces had been smeared on the bottom of those drawers. That indicated to me a malfeasance on the part of Mrs. Claiborne or someone acting on her behalf that justified a finding that she should be required to make Mr. Claiborne whole. The fact is, in most divorce cases of very short marriage, the idea of the court is to hold that parties would be restored to the same position they were in prior to the marriage. Mr. Claiborne owned that house before. He owned all of those properties beforehand and all of those personal properties beforehand, and that they were missing at the time. We had an extensive hearing where we went through all of the list of items that Mr. Claiborne had that he testified were missing. And the court found that it was justified to hold that she was responsible for their removal while she had possession. It's kind of like what we studied in law school. You know, when you were in possession of someone else's property, you're kind of in bailment of it. And when it goes missing with her situation, that obviously she had a number of people there in the house. Some of those were, you know, not particularly reputable characters. And in fact, I think one of her friends testified against her at the final hearing in this case anyway. So I found that she was responsible for the loss of all of those items of property, and that Mr. Claiborne was entitled to the return of those items, and that she had them or she had destroyed them. And if she had them, she could return them. If she destroyed them, she was liable for the value. I had a hearing. I made a finding as to the valuation of that property, and I ruled that she was responsible for it and that she should make those payments. And she failed to do that, and that's where the order for contempt came in. And I found that she was in willful and deliberate contempt because those items had been removed or damaged. She knew, you know, either where they were or she was responsible for them. And as a result of that, I think it was just that I enter that order. That is no different than if a father or a husband had dissipated assets. Let's say instead of personal property in the home, there was a $50,000 checking account, and one of the spouses had surreptitiously removed that $50,000 checking account. They would be held responsible for that money. And that's the same thing I did in this case. As a result of that, I'm of the opinion that the motion to alter amend that Mr. Guerin has filed, and I've considered it, and his argument that it should be converted to a criminal contempt and 10 days in jail is denied, because I think that I was correct in my ruling initially. But as I have pointed out, even in a case where a father owes substantial amounts of child support, after a period of incarceration, it is usual for the court to give that person an opportunity to be released by suspending the balance of the sentence and then allowing them to be back out on the street, so to speak, trying to find a job and trying to find a way to pay this. This court is of the opinion I was correct in the amount that I set or the items that would be returned. If items have been returned to Mr. Claiborne that since the entry of that order, then those items, the valuation was set forth in the order that was found, and those items, the value of those items would be deducted from the amount that she owes, just like a payment had been made on child support. The remaining balance would be her responsibility, and therefore I find that the appropriate and equitable matter in this matter is not to amend or alter the order, but rather to suspend the balance of her sentence for civil contempt at this time, allow her to be released with the condition that we set a review. I think I'm back here in September, and then again in, when am I back? January? We'll set it for review in January to determine whether or not she has made any progress in retiring. And I'll be honest with you, if she's making payments towards that satisfaction of that debt, then just like a father in a child support case, I will give her an opportunity to continue doing that. The January the 5th, how about let's make it January the 26th. That'll give her a full period of time. January 26th, we'll set a review date on this case. In the meantime, she is released with the understanding she is going to make progress towards satisfaction of the debt, and then we'll take a look at it at that point in time. Yes.
So part of the issues was her not receiving notice. That was in the motion.
One of the issues was what?
Her not receiving notice of some of this stuff at the end, and I did what I was supposed to do. I did the certificate of service to her 2 physical addresses I had and her email. Can we put in the order that she's required to let the clerk know what her current address would be?
It is the responsibility of all pro se litigants, or if you have an attorney, that she must keep in touch with the clerk's office and give us a valid address. So Mr. Guerin, I will put in the order that your client must provide Mr. Holly with her current address. That's fine, as long as the fact is that she's being released, but on a specific review date, then I want to know where she's living, because if she doesn't comply with the court's order, if she just vamooses, then we're going to have to issue a warrant for her. And I'm not going to arrest you. I'm going to send it for her.
Yes, sir.
So I think the best thing to do is to just require that she provide you with her current mailing address. Now, when she has that address, the order will provide that Mr. Claiborne is to have no contact with her. In other words, if he doesn't contact her by mail, by phone, or any other means, and she should not contact him. Let's just separate them. They don't need to be together, and I'm making that a rule. But I do think her address being a part of the court record when she's released is no different than, again, I'm treating this like a father who's been behind in child support. So
I should make sure I'm doing the right thing and sending it to the right spot. If Mr. Guerin wants to be responsible, I'll be more than happy to send it to him. And just to announce to the court, I may want to file some brief interrogatories about, basically her ability to pay. We think she may have a judgment. There's some other things. So I may want to ask a couple of questions about the receipt of the money for that judgment. And if we've got items that he's received, I will get with him. I will get with Mr. Guerin. We will attempt to work that out. If we can't, can we reserve that for the review date in January?
that's fine. I think it was Exhibit A that was the listing of the items that you had.
It is, and it's in my timeline. I put that June 18th order in that timeline, and I gave a copy of it to Mr. Guerin today. So if he'll, you should have Exhibit A in there for his records. Yes. There's a June 18th order in there, and it should have that
I
exhibit.
wanted Mr.
attached.
Guerin to be aware of the total amount of the judgment that was entered against her, so that's why. I'm sorry, how much? Okay. 42,000 and some odd dollars, all right. And whatever the value is of the property that, and all of that valuation is set forth on that Exhibit A, so deduct from that balance what is owed and
Yes, sir.
what the value of that property would be. And we'll go from there.
That's well understood, Judge. We'll do that. And then again, if there's any dispute, we can, if it pleases the court, I put that to order. We'll just reset that for January.
All right.
Can we reserve attorney's fees and have that at our review date as well?
Certainly. Well, we need to have an order signed that would allow it and set it for review. You all can draft even just a simple order that she's to be discharged subject to a review on, and then supplement that with a more complete order. Then that would be the best way to handle it. I'm gonna, if you can do it today, I'll sign it today. I saw Lieutenant Martin or Captain Martin or whatever he is, one of your witnesses. You want to bring him in here, we'll tell him what I'm doing, so in case that makes a difference for the jail. I have completely destroyed your files. I don't even know how I did that. All right. Excuse me for blowing my nose. I took it apart, probably. I'm ruling that we're going to let Miss Claiborne, I'm going to discharge her from jail today and subject to a review, and there will be an order. It'll take a little bit for them to get a typewritten order, but she's going to be discharged on the civil contempt and be brought back in January for me to review what she's done. So I just want to let you all know so that even if she needs to get out of there, then y'all can let her out by my order to you today, because even if the written order takes a little bit.
Yes, sir.
All right. Thank you. Y'all are free to go, by the way.